May I please, Your Lordship? I beg to mention regarding a criminal petition for withdrawal, Lordship.
You want listing
Yes, Lordship.
when?
Tomorrow
Okay,
for withdrawal, Lordship.
okay.
Thank you.
May I please, Your Lordship? Lordship, I beg to mention for listing on anticipatory bail, Lordship. It was filed yesterday, Lordship, and the lady has a small kid of 3 months. Kindly tomorrow, Lordship, already
Monday.
filed. Can it be tomorrow, Lordship? There is some urgency.
What urgency?
Police is constantly disturbing, Lordship, calling for the petitioner, and she has a baby also, Lordship.
Monday, Monday.
Can it be tomorrow, Lordship? Please, kindly, Lordship.
Okay, tomorrow.
Deeply obliged. There was urgency. Thank you.
May it please, Your Lordship. Lordship, we have filed one criminal revision petition on 7/11. Can be allowed to be listed tomorrow? That is from 14th.
Tomorrow it may not reach. We have lot of items. If it get listed, there is likelihood it may be left over. You want to take the risks?
On Monday, Your
Okay,
Your Honor, we will take the result.
okay, tomorrow.
Deeply obliged.
Repeated lordship. Criminal appeal lordship, but filed on 2nd of November lordship. Release for tomorrow lordship.
Criminal appeal,
Because urgency is that tomorrow evening I'll be leaving for 2 weeks. I want to do.
tomorrow evening,
I'll be leaving to Guwahati lordship for 2 weeks. That's why lordship.
that is not an urgent.
And late lordship. On 2nd it was filed lordship.
Okay,
Much obliged.
My pleasure, Lord. Lordship, we are for listing a pending matter, Lordship, for orders, Lordship, and
next
service
week,
already.
next week,
Monday, Lordship.
next week on a date to be fixed by registry.
Lordship.
Please, Your Lordship. Lordship, I beg to mention I am listing for tomorrow. I am
Next,
listing for tomorrow.
next week,
So, Lordship, only it will just take 1 minute. There is a typographical error in the petition. It will take just a minute. Lordship.
next week.
Please, Lordship.
No,
There is an urgency.
next to next week,
There is a urgency.
next month.
There is an urgency, Lordship.
Next week, don't insist, don't insist. Next week, Monday,
May I please, the Lordship? Lordship, I pray for listing of a bail application, Lordship, on Monday, Lordship. Lordship, it has filed yesterday, Lordship. It's a Monday.
okay.
Obliged, Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention a criminal leave petition for listing in the admission column.
Next week on a date to be fixed by registry.
May I please, Your Lordship? So I beg to mention item number 37. In the earlier occasion, it was called for FSL report, which has not yet been received.
In this case, those it is their lordship, but it need to be up to date because FSL is not received.
Item number 37.
Yes, sir.
What is your name?
I'm Sahir Arafat on behalf of Peter.
Mr. S. Arafat, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor, who submits that though the case diary is available, however, same is not up to date, and prays for placing an updated case diary on the next date fix. Prayer is allowed.
2nd December. Lord.
Let this matter be listed on 2nd of December.
Lordship, interim order.
The interim shall continue till next day.
Obliged. May I please, Your Lordship? Lordship, in connection with item number 31 and 32, my lord, we have filed on additional affidavit, my lord. That may be called for the case.
Call for the additional.
Deeply. May I please, Your Lordship? I'm praying for listing of a criminal petition for motion, Lordship. Can it kindly come on Monday, Lordship?
When have you filed?
We have filed on 17/9/2025.
Okay, on Monday. Monday.
Obliged.
May it please, Your Lordship, I beg for listing the matter, Lordship. Criminal petition, Lordship, 23 matter, Lordship. NBW issue, Lordship.
Next
So,
week. Next
Lordship,
week.
Monday, Monday.
Next week on a date to be fixed by registry.
May I please, the Lordship? I beg to mention for listing of IIA, Lordship. This order was passed.
Next week on a date to be fixed by registry.
Lordship, in the earlier direction was given, a Lordship. The modification of this order, Lordship.
When you want.
Tomorrow, your lordship. This is-
Tomorrow,
And this is the next date, your lordship, for appearance of this.
then you will please submit that matter has not reached. It is left over.
The last item tomorrow, your lordship, maybe.
Okay, tomorrow.
March of resolution.
My pleasure, Lordship. Lordship, I beg to mention for listing. For a bail application.
Next week, on a day.
Right.
Okay, tomorrow.
That's another,
Okay,
the matter was fixed for today, but it is not listed, my lord.
what is the matter?
Bail application, Poxo matter.
You give a mention memo on Tuesday,
What is
both matters on Tuesday. Yes, please call the items.
Okay, well.
May I please, your lordship?
Heard Mr. S. Rahman. Why are you withdrawing?
According to petitioner's instruction.
Heard Mr. S. Rahman, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail, instant criminal petition. The prayer is allowed. This matter, this criminal petition is dismissed on withdrawal.
Oblige.
49.
May I please?
Heard Mr.
I am in.
In.
I am in learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition. Prayer is allowed. This same order.
Bless.
This criminal petition is dismissed on withdrawal.
Item 50.
What is your name?
Vidas.
Heard Miss B. Das, learned counsel for the petitioner, who prays for allowing the instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
Item 51. Item number 51.
After some time.
This is motion here, item number 1.
May I please, your lordship? First, we already suspected matter, lordship. I was arrested, lordship, on 8/6,
Charge sheeted matter.
suspected matter, lordship. He is behind a bar from
First date, your lordship, we have received the copy. We
You
need.
will file objection.
Yes, sir. It's a parawise communication. This is the SIT matter of the Manipur. A number of FIRs are there, so we need to deal with meticulously.
copy of LCM.
What is your name?
Came in, lordship.
Heard Mr. A. Mena, learned counsel for the petitioner. Also heard Miss M. Kumari, learned special public prosecutor, CBI. This application under section 483 of BNSS has been filed by the petitioner Asim Kumar Singh alias Asim Kannan Singh, praying for his bail. Learned Special Public Prosecutor CBI submits that the CBI intends to file a written objection against the prayer made by the petitioner. The prayer is allowed. When will you file?
By first week of December.
Let
Because
this
we need
case,
certain approval from the
okay.
authorities, that is why it.
Let
requires-
this case be listed on 4th of December.
Lordship was sought. Lordship.
No, they have to take it 4th of December.
Lordship, scan copy of LCR and CD may be called for, lordship. It will be required.
LCR, why it would be required?
Lordship, there are two such it, lordship, and lordship, the case has been, there are also. bail-
What is your plea? What is your ground?
Lordship, on parity, we will fight, lordship. Already other
Clarity
activities
is
have.
not
Let them file the. Okay, let the scan copy of the connected case diary be called for.
Case study.
Obliged, lordship.
Much obliged.
This is a charge sheeted case, Lordship. And
Heard Mr. Charge sheeted case. What is the offense?
offense is, Lordship, NDPS, Lordship.
Commercial quantity.
How much quantity, Lordship, but here although it is stated that it was seized from his house, it was not, he was not in the house at that date, Lordship, because it was seized from the outhouse. I have that ground and one more ground, Lordship, those notices under 47 and 48 was never served.
Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Let the scanned copy of the trial court record as well as scanned copy of the connected case diary be called for from the trial court. Let this matter be listed on 2nd of December.
Let it be, because I will not be in the first week, in second week,
11th of December.
11th of. Lordship. Lordship, from last 97 days, I am on the bar, Lordship, and this
How many days?
97 days, Lordship. And this case is part of immoral trafficking prevention act, Lordship. And I am the manager of the hotel and owner of the hotel. Already, this honorable court already pleased to pass an order by granting bail, Lordship. And that order is,
It is pending investigation
yes, Lordship.
or charge sheet has been filed. What is the maximum period?
90 days.
Then why have you approached this court? You could have approached the trial court if statutory period is over.
So, but prior to 90 days, I have prepared this bail application. Now it's
When have you filed this bail application?
filing date is Lordship. Maybe.
Or 11.
Yes.
Now we have to verify whether 90 days we have to call for the records.
Yes.
Instead, you can directly approach the trial court.
Yes.
There you will get bail.
Lordship, for your kindly peruse Lordship, page number 21, there is the previous order of this honorable court, Lordship, where it is stated that, Lordship,
Yes.
Lordship, here, Lordship, already this court, in page number 22, para number 4, Lordship,
No, we are questioning your approaching this court
yes.
after completion of 90 days. That is not proper.
Yes.
You. Otherwise, we'll call for the case diary. We have to wait. You approach the trial court if 90 days are over.
If honorable court please to give some observation in this regard, so that we can move forward.
Yes, Mr. Bhattakur.
I will have to get the instruction whether search is submitted or not.
Oh, whether charge sheet has been submitted or not. Okay, take that instruction.
Yes.
We'll call for the case diary. Heard Mr. N. Pathak, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner has been detained behind the bars since last 90 days and maximum period of statutory detention, maximum period of detention during during the period of investigation for the offences involved in this case is 90 days only. On this, learned additional public prosecutor submits that he may be allowed some time to verify as to whether charge sheet has been laid in this case or not. The prayer is allowed. When?
Tuesday.
Let this matter be listed again on Wednesday, 19th of November.
Just hold.
May I please the lordship. Regular bail application, my lord. 65.25 gram drugs has been recovered. My lord, intermediate quantity. Today is 37 days, my lord. CD may be called for, my lord.
Heard Mr. H.A. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bhattakur. Call for the case diary. Let this matter be listed
On my lord,
to
9th of December.
9th of December. 9th of
9th
December will be two,
Will be over, my lord.
It will.
21.
2nd December.
Just five. Agenda number 5.
After some time.
6.
Lordship, matter may,
I am the petitioner.
yes, matter may be taken
want
up
to move
after
the
some
matter?
time. No. After some time.
Your,
Yes.
your fault?
I am from B. Sharma on behalf of S. Kolita. Matter may be taken up after some time.
No, you are appearing for
Appearing for special PP wildlife.
special PP. Okay.
These are bats. Baduli, bats.
Let the,
These are not rhino, neither any. 40 days he's in custody. Some
but it
bats,
may be endangered species.
but endangered, so nowadays bacteria are also endangered.
But if it is protected, then you are in
Actually,
trouble.
this wildlife amendment.
Let the PP, special PP come. We'll take it up after some time.
7.
Please, your lordship. Charged case, lordship, commercial quantity.
What is your ground?
Counts is there, lordship. 47 and 48. 36 is also there, lord. 36 under section 36 of BNSS. Section.
36 is not mandatory. On that ground, you will not get bail.
Length of detention is there also on
How much length?
As on to the
If you
221
don't
days.
have a case, we may not call the scan copy.
221 days as on today.
That is also not sufficient. Any other ground?
And also petition for bail rejected by the lawyer court also. Right.
No, I am not getting it.
Bail prayer which has been rejected by the trial court lordship.
Now, why this court should grant you bail?
That is that also.
If you don't have any ground, will not admit this bail application, will dismiss it because of the embargo of section 37. How you will overcome the embargo?
Engineer would submit if there any judgment regarding 36 BNSS lordship. In the meantime, PCR may be called for.
No, you come prepared. Otherwise, we'll dismiss it. We'll take it up after some time or tomorrow.
Tomorrow.
Okay. On request of learned counsel for the petitioner, Mr. What is your name?
Yes, Hussain.
Mr. S. Hussain, who prays for some time for producing some authorities in support of the contentions made by the petitioner in this bail application. The prayer is allowed. Let this matter be listed on Wednesday.
God bless. Item 8.
Lordship, I have been arrested on 28/2025 and this is an NDPS case falling under commercial quantity, wherein Lordship, I have been made a scapegoat. And I have been made a victim of the circumstances because Lordship, the alleged premises from where the contraband has been recovered, I do not take possession of any of the premises. Further, Lordship, I just went to the place of occurrence to meet my husband, who is the other co-accused, and therein I was arrested. Nothing has been recovered from my physical or conscious possession, Lordship.
It is pending investigation.
Spending investigation. Apart from this, Lordship, another ground is that, Lordship, in the very recent judgment of the Honorable Supreme Court, Lordship is maybe well aware that the Mihir Rajesh Shah, which said that 2-hour rule before remand, the arrestee has to be made aware of the grounds of arrest 2 hours prior to the arrest.
Yes.
So that has not been complied with. As because, Lordship, this is the notice under section 47 that I have. Certified copy you can.
Okay, we'll call for the case diary.
Just once, Lordship may look upon the notice. Lordship, in the said notice, what the recent judgment says that 2 hours prior to the arrest, Lordship, to my little understanding, this judgment of Mihir Rajesh Shah has given a liberal view, a liberal approach to the arresting authority and giving them a 22 hours of time frame to prepare for the arrest procedure, wherein only 2 hours have been given to the accused person. In this instant case, the notice have been served to me at what time I was produced before the learned magistrate and at what time I was served upon this notice. There is no clarity on this.
But what is your contention when it was served?
It was served after that, after my arrest, and it was not served to me. I just got this certified copy after filing of the bail application, Lordship.
Okay, we'll examine. Let the case diary be called for. Ito return. Heard Miss S. L. Banik, learned counsel for the petitioner. Also heard Mr. P. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Perusal of the case diary would be necessary to consider the contentions raised by the learned counsel for the petitioner in this bail application. When
On 9th of December, 9/12.
9th of? Give a shorter date.
On 2nd of December.
Let this case be listed on 2nd of December.
Maybe last week of November.
On 28th of November.
28th.
May please, Lordship. Lordship, I may be allowed to withdraw the petition. Some additional documents has to be annexed.
Heard Mr. M. Rahman, learned counsel for the petitioner. Also heard Ms. N. Kakoti, learned counsel for NCB. Learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant bail application. The prayer is allowed. This bail application is dismissed on the ground.
Obliged.
Bail application. In connection with Goribul Police Station case number 355 of 25 under section 22C and 29 of NBPS Act.
What are your grounds?
Grounds is Lordship 47 and 48 violation is there, Lordship. 47 and 48 Lordship. In case number starts 33 to 40.
What violation? Where is 47 notice?
47, 30, 33 Lordship. This starts from 33.
What violation you are alleging?
Whatever. What are the recovery? Nothing has been mentioned in this 47 and 48 notice that. Only these are the grounds available, but this is seems to be reasons for a Lordship.
What was recovered in this case?
In this case, Lordship, 672 spas tablets.
From whom?
From both petitioner.
That is, okay.
And,
We'll call for the case diary. Heard Mr. S. Hussain, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Call for the case diary. Let this matter be listed when?
On my 5th of December.
5th of December.
short date may be given husband and wife Lordship. There are children and Lordship. They are suffering.
2nd of December.
2nd December.
God bless.
Matter, sorry. Lordship, matter relating to Wildlife Protection Act. Lordship, and case has been registered under section 9, 39, 49 B and 52,
One special PP one.
Wildlife. Let the special PP come.
Lordship, then at two Lordship.
Okay, at 2.
May I please, your Lordship? Lordship, it's an underwear matter, Lordship. Lordship, we have filed criminal revision petition along with the bail application, Lordship. So the criminal revision petition is not been listed here. So kindly the matter may be listed together, Lordship.
How it is linked?
Lordship, the same matter.
How it can be same matter?
Lordship,
It is for release of a detained person.
yes, Lord. Lordship, criminal revision petition has been filed against the order dated 31/7/2025, where I have been, where charges have been framed against me, Lordship.
Okay, that is a different matter.
Lordship,
And-
the TCR may be called for the same matter, Lordship.
No. Bail will be considered separately. What are your grounds in this case?
Check the quantity is, it's not a commercial quantity. It's an NDPS matter.
Commercial quantity.
Charge sheeted case. But it is showing commercial quantity. What was recovered?
Cough syrup bottle,
How much?
18.84 gram. Lord.
How many bottles were recovered? Okay, Mr. What is your name?
Abraham, Lordship.
Hey, Brahma, you should go through the brief before appearing before the court. Heard Mr. A. Brahma, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Let the scanned copy of the records of special NDPS case number 165/2025, 2024, as well as scanned copy of the connected case diary be called for. Let this matter be listed
On my 5th of December.
on 5th of December.
Please, Lord. Item 52 for supplementary release.
May I please, your Lordship? This is a bail application, your Lordship, whereby the accused petitioner for whom I am appearing is the co-accused, your Lordship. So Lordship may at first come to page 11 FIR. May I read it, Lordship?
What is your contention?
Yes, Lordship. On the 2nd October, Lordship, there was Durga Puja, and on that occasion, there was a Bhavna which was held in the Puja committee, by the Puja committee, organized by the Puja committee, and the petitioner before your Lordship,
What is your name? Name of the
his name is Biki Bora,
Vicky Bora.
Lordship.
Okay. Yes, what happened?
Lordship, then what happened? He went there, he is a driver of a generator set vehicle. He is a commercial vehicle and he has his commercial driving license. So accordingly, he went there and for the whole night, he performed his duty. And in the morning of 2nd October, when he was released, he was about to come back with his vehicle. At that point of time, this main accused, Bijoy Gon, whose name is in the FIR, but my accused is not FIR name. So Bijoy Gon came in his vehicle and asked him to drop this girl who is 13 years of age in near Bapuji school. There was a school, LP school. So accordingly, he provided them the lift.
Let the case diary be called for. List this matter accordingly.
And Lordship, I don't hide the facts. As per my information, the incident occurred on 2nd October. These co-accused were arrested on 6th October. He was called to the police station and he went to the police station, then he was arrested. And the main accused was arrested on 12th October. And on 12th October, Lordship, that girl committed suicide.
Girl is
That girl
dead.
committed suicide. As per my information. Because I won't hide anything, Lordship. Whatever I know, I'll disclose.
Okay, let the case diary come.
Lordship. 14.
May it please your lordship. Well, page 14 is the FIR. Whatever, the petitioner before your lordship and the girl, my lord, they work in two different malls, my lord, in Guwahati, my lord. Then in a, both are major, my lord. Then, my lord, to be frank enough, my lord, they had a relationship, my lord. Eventually, the relationship turned sour, my lord. And, my lord, this case has been registered, my lord. But there was no allegation of any forceful anything, my lord. Page 14 is the FIR.
69. We'll go through the case diary.
But lordship, may kindly see, my lord, there is no allegation of anything, my lord. No, in page 14, my lord. Page 14, my lord. Both of us, only allegation that they had a relationship, he promised something, my lord. Now he is not contacting, my lord. That is the allegation. No, my lord, anything beyond that, my lord. Lordship may call for the case diary, my lord. Lordship may protect me because both of them are major, my lord.
Yes, Mr. Bhattakar.
On the pretext of marrying her, my lord. Yes.
Okay, heard Mr. S.M. Abdullah P. Learned counsel for the petitioner. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Jitumani Das, who is apprehending his arrest in connection with Bhangagor PS case number 176/2025 under section 69 of the BNS. The gist of accusation in this case is that on 30/10/2025, the victim girl had lodged an FIR. No, the mother of the victim girl had lodged an FIR, inter alia alleging that the petitioner was in a romantic relationship with the daughter of the first informant, within bracket victim, since last 2 years. And they had physical relationship on the pretext that they will marry each other. On the pretext that the petitioner would marry the victim girl. However, now the investigation, however, why you are apprehending? However, as police is searching for him, he is apprehending his arrest. On the other hand, an additional public prosecutor prays for calling of the case diary. let the case diary be called for. Let this case be listed on 9th of December 2025. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the above named petitioner is allowed to go on, is directed to appear before the investigating officer of Bangagaon PS case number 176/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. Please.
Right.
comment.
14. May please, your lordship. It's an anticipatory bail application. Petitioner before your lordship and the informant were in a confidential relationship. Subsequently, the petitioner finds out that this informant was already in another relationship with another person against whom she filed a case of rape, took money and withdrew the case. So he also apprehended that similar thing could also happen to him. So he ends the relationship. When he ends the relationship, the very thing he anticipated also happens to him, madam. The lordship will kindly come to page 11, madam. This is the FIR lodged against the petitioner. May I read that? Madam?
Yes,
Sir, I am a resident of so and so place. I am 29 years.
29 years.
Yes, a divorced woman and under great distress. Taking my distress as advantage, the accused person approached me and told that he got separated from his wife, as she is not a good lady. He told that he loves me and would marry me. He wanted to have sexual intercourse with me, but I denied and told him categorically that she would allow any such thing only after he marries her. This would perhaps be I, madam. That on so and so date, he took me to Panimur waterfalls for roaming. After an hour of arrival at Panimur, he told me that he is very tired and he needs some rest. To take rest, he took a room of cottage in rent there and asked me to go with him in the room. First, I did not want to go, but when he assured me that
So,
he would not do anything wrong.
Allegation is of forceful.
No, madam, apart from she alleges that, then hereafter on multiple occasions, she goes with him to different places. It's all there in the FIR. She stays with him in different resorts and hotels, madam. Subsequently, she comes and says that now he has refused to marry me. And this is the allegation of rape. Now, your lordship will also come to page 13, madam. Same informant also lodges a complaint alleging similar allegations against another person. Same allegation of having persuaded her to have a sexual relationship with him by luring her into marriage. She even gets pregnant. This complaint gets lodged. Now at page 19, she withdraws the complaint saying that the matter has been amicably resolved. So when I find out about this case, and I see that such a thing has already happened in the past, so I end my relationship. If I had committed any forceful intercourse with her, she would have lost the FIR at the very
Your
first instance.
submission is that it is consensual.
Consensual manner for an extended period of time. Only after I break up the relationship. with
Yes,
her.
Mr. Bhatt.
Yes, my lord, prima facie, my lord, it seems that earlier also, my lord, he has lost one case against one other.
Whether case diary would be required.
Yes. Let them, my lord, let him record his statement later and CD may be called to me.
Okay. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Navaratan Sharma, who is apprehending his arrest in connection with Lanka PS case number 231/2025 under section 127/64 within bracket 1/69 of BNSS. the gist of accusation in this case is that the victim woman had lodged an affair on 15/10/2025.
One thing,
Mm.
Madam, may I point out, though the FIR is dated 15/10, the Lordship will see that it was lodged on 28 on page 10, Madam.
Lodged an FIR dated 15/10/2025 before the officer in charge of Lanka Police Station, inter alia alleging that the victim is a divorced woman of 29 years of age, and she got acquainted with the present petitioner and developed a romantic relationship. It is alleged in the FIR that on 31/3/2025, the petitioner forcefully committed sexual intercourse with her, and thereafter, on many other occasions, they had physical relationship on the pretext that the petitioner would marry her. Marry her. Stop. However, it is alleged that since 12th of September 2025, the petitioner stopped all kind of relationship with the victim woman. Stop. It is alleged that the victim was subject to sexual intercourse on the pretext of false promise to marry her made by the petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner is a adult lady of 29 years of age. No, sorry, the victim is an adult lady of 29 years of age. And she had a romantic relationship with the petitioner for how much time?
For 8 to 9 months, Madam. 7 to
For-
8 months, Madam.
For about 7 to 8 months. Stop. He further submits that later on the petitioner came to know that on an earlier occasion also, the victim girl had romantic relationship with another person with whom she also had physical relationship. And later on, she lodged an FIR or complaint, a complaint alleging forceful sexual intercourse against the said person. He further submits that subsequently the complaint was withdrawn on the ground that the matter has been amicably settled between the parties. On coming to know about the alleged incident, fearing the same fate with him, the petitioner broke the relationship with the victim girl, and therefore the instant FIR has been lodged. The learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation. However, since the police is searching for him, he is apprehending that he may be arrested in connection with the above mentioned case. On the other hand, learned additional public prosecutor prays for calling of the case diary. Let the case diary be called for. Let this case be
11-12, man.
listed on 11th of December. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the above named petitioner is directed to appear before the investigating officer of Lanka Police Station, case number 231/2025, and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions, number 1 and number 2, list accordingly.
Petitioner elder brother was randomly picked up by the complainant, my lord. The SI border of Muraja PS, my lord. And can we see page 18? And after arrest, my lord, he made an inquiry report, my lord, and alleging that the suspected foreigner, and he produced some certificates, documents, my lord, the A, B, C, D, some PAN card, voter ID, and other documents. But he alleged that this document has been forged and manufactured, my lord. And he, my lord, submitted this report to the OC Murajar PS, and OC Murajar PS, my lord, registered a case, my lord, and forwarded him to the judicial custody, my lord. My lord, I am
was
the
sent.
brother of this person, my lord. Now that police officer border, my lord, he charging me, my lord, and he wanted to arrest me in this case, my lord.
What is your name?
Reflected in the inquiry report that I am the brother of the person he earlier arrested, my lord.
The FIR was against Abdul Shahid.
Abdul Shahid, my lord.
What is your name?
My name, Saleh Ahmed, my lord. It is the inquiry report, my lord. He is the brother of Abdul Shahid.
Your name is
Saleh Ahmed.
Saleh Ahmed.
And my lord, if he is a suspected, my lord, foreigner, then he may, my lord, prepare a inquiry report and forward it to the SP, and if, my lord, SP may forward it to the foreigners tribunal, my lord. So that he kind of alleged that he forged the documents, therefore the section of PNS has been implicated in the case, my lord.
Yes.
My lord, while allegation.
You are otherwise not declared foreigner.
No.
Okay.
Otherwise, allegation is of forging documents. My lord,
How can he ascertain that this document of forging without any inquiry, without verifying the document,
Without investigation.
without investigation?
Okay. Heard. Mr. A.J. Atia, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Saleh Ahmed alias Saleh Aham
Ahmed. Mistake of his signature, my lord, that's fine.
Saleh Ahmed, who is apprehending his arrest in connection with Murajhar PS case number 121/2025 under section 61 within bracket 2/319 within bracket 2/336 within bracket 3/340 within bracket 2 of BNS, read with section 14 of the Foreigners Act. The gist of accusation in this case is that on the basis of an inquiry report submitted by
By
By-
SI border,
by one Isfakul Haq, SI order against inter alia stating therein that one Abdul Shahid, resident of village Dakhin Debostan under Murajhar PS is suspected to be Bangladeshi national. And during inquiry, the said Abdul Sahid produced certain documents which are alleged to be forged documents. An FIR was lodged by, said Isfakul Haq before the officer in charge of Murajhar police station, on the basis of which the aforesaid case was registered. Learned counsel for the petitioner submits that the name of the petitioner, Saleh Ahmed, has been shown in the said FIR as the brother of the main accused Abdul Shahid. However, the police is now searching him, alleging the petitioner to be a foreigner of TW2. Learned counsel for the petitioner has submitted that the bare perusal of the FIR shows that the brother of the petitioner was suspected to be Bangladeshi national. Even if it is, he submits that even same is believed to be true. Even the suspicion is to be taken into account. The due process of law has to be followed for verifying as to whether the brother of the petitioner is a Bangladeshi national or not. However, instead of referring the matter to Foreigners Tribunal, the FIR has been lodged against the brother of the petitioner. Learned counsel for the petitioner, what is your claim? You are an Indian citizen. Learned counsel for the petitioner submits that the petitioner is an Indian citizen and has all valid documents. However, he apprehends that if the However, as police is searching for him, he is apprehending his arrest. He further submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Let the case diary be called for. Let this case be listed on 16th of December. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the petitioner is directed to appear before the investigating officer of Murajhar PS case number 121/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with aforesaid case.
Or any other, he may put any other case instead.
No, this,
As his brother. My lord,
But-
can we see
but-
his brother has. First, my lord, he arrested and then, my lord, this inquiry.
you cannot be given blanket. Suppose the murder
Yes.
case is pending. You can be given protection only against this case.
Yeah.
Calika last line only. Aforesaid case, he may be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. List accordingly.
To the. To the, my lord.
Satisfaction of the
Satisfaction of the.
arresting authority.
Yet some.
Then whose satisfaction? In anticipatory bail application.
Like,
Oh.
he may create another problem.
No,
Yeah.
you tell me, what should I write? What should be the direction?
To see how it is, my lord. To see how it is, same everything is on.
Subject to whose satisfaction? Suppose you are arrested,
My lord.
then who will give you bail?
Which is satisfaction, subject to my lord. Only may- Which is satisfaction, the satisfaction of the IO.
Yes, that I have mentioned, the satisfaction of the arresting authority.
Subject to my lord.
No, I am not getting you. What you want to say? I have directed that if you are arrested, you will be released on bail subject to satisfaction of the arresting authority.
Yes, my lord, he say, okay, my lord, but he takes on.
Now, what do you want?
Lordship,
I have already dictated the order.
his lordship, has not dictated you, my lord. I am not. So,
No, you have to assist the court if court
actually, sometime, my lord, they get act. My lord, can you see, there is no any case, man. He is
No,
being
therefore you are
supervised.
given interim relief.
Yes, my lord. Let's see, let's see.
Next slide.
Police.
May I please, your lord? 3 years bail application, my lord. Also kindly see at page 10 FIR, my lord. Informant, my lord, all the accused persons are same family, my lord. Is the brother-in-law, father-in-law, mother-in-law, and sister-in-law, my lord,
376.
my lord. Actually, there is a dispute of a land dispute between the parties, my lord. I have stated in my paragraph below, lord.
Who are the petitioners?
Petitioner now, lordship, petitioner number 1, Matiur Rahman,
He is the
before your lordship,
main accused.
my lord.
He is the,
My lord, the police, my lord, asked them, all the accused person appeared before the police, my lord. And one filed charge sheet was filed, my lord.
It is a charge sheeted
Yes,
case.
my lord. At the time of charge sheeted, my lord,
Suspect statement.
charge sheeted, my lord, all the accused person not sent up was shown in the, my lord. And petitioner also, lordship, was not shown as a absconder, my lord. He was interrogated and statement was recorded, my lord, and after filing the charge sheet, my lord, the learned judicial magistrate first class issued notice, my lord. Now, my lord, this court is not trial court, my lord. Petitioner is apprehending, my lord. If he appear, my lord, he may be arrested, my lord.
Yes.
Petitioner.
Why he may be arrested?
Petitioner is the, my lord, brother-in-law of the, my lord, victim. In absence of her husband, my lord. The allegation is that he, my lord, he entered inside her room and thereafter committed this offense.
Your statement was recorded.
I have make a statement, lordship, paragraph 4, my lord. What actually,
Where is the order of the trial committal court?
lordship, kindly see at page 20, my lord.
When is the next date
Next
fixed?
is, lordship, 28, my lord, 28 November.
And now whether summons have been issued or warrant have been issued?
Someone issued, my lord.
Still it is in the stage of summons.
Yes, page 21, my lord, summon.
Where is the bar that the court cannot grant you bail? There is a bar somewhere. Where is that bar?
It's Sakam, my lord, similar court will bench, my passing order, my lord, three similar. order.
No. Answer my query.
My
Where
lord,
is the,
This court is, my lord, actual trial court is, my lord, session court, my lord.
no, I understand. The committal court is not the trial court. Why committal court cannot grant you bail? There is a bar somewhere in the BNSS.
Normally, my lord,
No, there is a bar. You find out the bar.
no bar, actually there is no bar.
No, if no bar, I will reject this bail application. There is a bar on the part of, you read section 480. You show me the bar, I will grant you bail. We'll take it up after some time. Day after tomorrow. Okay. On request of learned counsel for the petitioner, let this matter be listed on Monday, on 17th of, you come prepared. Yes.
May please the lord. So this is the second time petition, my lord. Petitioner, my lord, is the mother-in-law, my lord. Husband was arrested, wife committed suicide. And it was husband was arrested, he was released on bail subsequently, my lord. Father-in-law and sister-in-law was also released, my lord. Up to date diary may be called for, my lord.
Who rejected the earlier case?
Case 19.
Why it was rejected?
So in the initial stage, my lord, there was some material was found, my lord, against.
Okay. Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. Call for the case diary. Let this matter be listed.
On, my lord, 2nd of December.
2nd of December.
May I please, your lord. Lordship, by this criminal revision petition, I have challenged the order dated 29/2025. Annexure 4, page number 19. My lord, petitioner was filed a Zimma petition before the court below for a vehicle which was seized by the Zurabat outpost dated 13/6/2025.
Yes.
19, my lord. In this order, last portion of the order,
may I read, my lord? Since the fertilizer are presently stored within the sales vehicle themselves, bearing so and so, bearing registration number so and so, and due to unavailability of alternative storage space at Zorabat outpost campus, the release of said vehicle on Zimma at this stage is not feasible. Considering the aforementioned reason cited in the Zimma report and being satisfied by so, I do not see it fit to allow the Zimma of the aforesaid vehicle at
Who is the owner of the seized fertilizer?
As owner of the seized fertilizer, my lord, this government only. This fertilizer, my lord, kindly see the annexer. Annexer 2, my lord. Schedule list. Page number 16A.
Yes, Mr.
Your
Bhatt.
lordship may kindly come to page 18, my lord, last portion, I will point out. Second paragraph, my lord, 1, 2, 3, 4, 5, 6, from 7th line, my lord. The IO, my lord. The IO has also stated that a prayer has already been submitted before the Honorable District Magistrate for confiscation of the seized fertilizers along with the aforementioned vehicles under Section 6A of the Essential Commodities Act 1955 in compliance with the confiscation proceedings as per order memo number so and so dated. Second page. 4825 issued by the Office of the District Agricultural Officer Kamrup, the seized fertilizers and the vehicles mentioned above have been confiscated at Jorabat Police Outpost, and Sri so and so SDAO has been duly authorized to initiate further proceedings under Section 6A2 of the Essential Commodities Act. So, my lord, confiscation proceedings is underway under Essential Commodities Act. So, my lord, I will have to probably alternative remedy for the accused, for the petitioner is there under,
To appear before.
yes, before the district magistrate, my lord, he can file appropriate application.
My lord, on the fertilizer, for the fertilizer, 280 bags of fertilizer, for which
For
One-
releasing of the.
confiscated has been taken. Only 240.
No, but it says
But-
that
For keeping that fertilizer, only says is not given. Says a vehicle is not given. Only keeping that fertilizer into the vehicle, my lord.
we'll call for a report as regards the status of the confiscation proceeding. Heard Mr. A.S. Ahmed, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 442/438 of BNSS has been filed by the petitioner Salman Khan, impugning the order dated 29/2025 passed by learned judicial magistrate first class Kamrup Metro, whereby Jimma application, whereby prayer for Jimma of the Jimma of the vehicle,
Vehicle only, my lord.
Jimma
only
of the seized vehicle bearing registration number AS 28C9430 was rejected by the said court. Learned counsel for the petitioner has submitted that the petitioner is owner of the seized vehicle, which was carrying fertilizers.
My lord, petitioner is, I am not absolute owner. he made an power of attorney with the absolute
Then
authority.
the absolute owner has to,
You are not the registered owner.
I am not not a registered owner, but I have given a power of attorney.
The petitioner is the power of attorney holder of the power of attorney holder given by the registered owner of the vehicle in respect of the seized vehicle. However, his prayer for Jimma was of the seized vehicle was solely rejected on the ground of unavailability of alternative storage space of the seized fertilizer. Stop. Learned counsel for the petitioner has on the other hand, learned additional public prosecutor has submitted that since it appears from the impugned order that confiscation proceedings in respect of seized fertilizer, case diary would be there,
yes, ma'am.
seized fertilizer as well as vehicle has already been initiated. He may have to take instructions in that regard. The prayer is allowed. The petitioner shall take, the additional public prosecutor shall take instructions regarding the status of the confiscation proceeding in respect of the seized fertilizer / vehicle if already initiated, and let this court know about the same on the next date fixed. The learned additional public prosecutor is also requested to produce the case diary of Basishta PS case number 324/2025 on the next date fix. Let this case
On
listed on
27/11.
27th of November.
Where the company is before lordship, receiving an order of issuance of pre-cognizance notice and the entire proceeding. Your lordship may kindly come to page 53 first, my lord. That is the notice, the order issuing notice, page 53.
Yes.
May I read it now?
Yes.
Today is fixed for necessary order. Complainant is present, heard learned counsel appearing for the complainant. On perusal of the case record, it reveals that there is a complaint filed under section 316-357 of the BNS filed by the complainant, issue notice to the accused person under section 223 of the BNSS. Now, your lordship will kindly notice that, my lord, this order does not reflect that the, my lord, the learned additional chief judicial magistrate has even perused the complaint. It only says, my lord, on perusal of the case record, it reveals that there is a complaint filed under section so and so, but perusal of that, an application of mind is not there. Now, your lordship may kindly come to the, my lord, complaint petition, which is at page 38. The complaint has been filed by the
The
sitting MLA of
complainant
the-
has not been examined.
My lord,
Whether complainant was
no,
examined.
my lord. Nothing has been examined, my lord. Let's read one paragraph where, my lord, the main allegation in the complaint is there, my
Page
lord.
number?
Page 40, paragraph 6. The allegation is that so far as the responsibility of the company regarding corporate social responsibility, CSR, that has not been adhered to, and that is the allegation, my. Paragraph 6, may I read, my?
Yes.
That in the said meeting, there was a meeting before the, my lord, with the, my lord, authorities.
that in the said meeting, the complainant expressed the grievance status and genesis of the tea garden communities in the presence of your authorized representative for a harmonious situation. It is pertinent to mention here that corporate social responsibility concept in India is governed by Section 135 of the Companies Act, Schedule 7 of the Act, and Companies CSR Policy Rules 2014, wherein the criteria have been provided for assessing the CSR liability, eligibility of the company, implementation and reporting of the CSR policies. Accused is bound by the statutory provisions to meet the wants of the people. Accused is running their activities and creating enormous hardship to the people of Selenhat Tea Estate and adjoining area. And it is the responsibility of the accused to act towards welfare of the local community as compensation of the adversities caused. Then, my lord, paragraph 7 also your lordship may read, my lord. The complainant states that no visible CSR contribution for the purpose of education and health has been made by the accused for the tea garden community. So, my lord, this is the allegation that the responsibility under the Section 135 of the Companies Act has not been, my lord, adhered to by the company.
What offense is alleged?
My lord, the offense is under, my lord, Section 135. Your lordship will kindly peruse 135, my lord, there is no criminal liability.
No, they have mentioned section 316 and 357 in the complaint petition.
Yes, your lordship will look at that also, my lord. Prior to that, your lordship will see, my lord, what is the liability of a company under Section 135 of the Companies Act.
Yes. One 135 is not a penal provision.
It's a, there is a penalty provision. my lord.
Penalty is
Yes,
there.
my lord. Penalty is there. That is the, my lord, limited liability. In the event, my lord, it is proved that we have shown documents, my lord, here showing that, my lord, we have performed our CSR liabilities. But then, my lord, even assuming that we have not, the only thing is, my lord, the fine can be imposed. There is no criminal liability. That is my case. Your lordship will kindly produce Section 135.
No, for imposing that fine, whether criminal case has to be instituted.
No, your lordship will kindly, that's why, my lord, I'm imploring that your lordship will kindly go through the provisions of Section 135.
Yes,
Section 135, for, has your lordship got in mind?
yes.
Corporate social responsibility. Every company having net worth of rupees 500 crore or more, or turnover of rupees 1000 crore or more, or a net profit of rupees 5 crore or more during the immediately preceding financial year shall constitute a corporate social responsibility committee of the board consisting of 3 or more directors, out of which at least one director shall be an independent director. Then your lordship may skip and come to subsection 5.
Yes.
The board, that is my lord, board of the company, of every company referred to in subsection 1 shall ensure that the company spends in every financial year at least 2% of the average net profits of the company made during the 3 immediately preceding financial years, or where the company has not completed the period of 3 financial years since its incorporation during such immediately preceding financial year in pursuance of this corporate social responsibility policy. Now, my lord, what are the preferences to be given? That has been notified, my lord. Then, my lord, your lordship may kindly come to subsection 7.
Yes.
May I read that, my lord?
Yes.
Subsection 7. If a company is in default in complying with the provisions of subsection 5 or subsection 6 of the company shall be liable to a penalty of twice the amount required to be transferred by the company to the fund specified in Schedule 7 or the unspent corporate social responsibility account, as the case may be, or 1 crore rupees, whichever is less. And every officer of the company who is in default shall be liable to a penalty of 1/10 of the amount required to be transferred by the company to such fund specified in Schedule 7 or the unspent corporate social responsibility account, as the case may be, or 2 lakhs rupees, whichever is less. My lord, this penalty is imposed, my lord, by the Ministry of, my lord, Corporate Affairs. There is, my lord, criminal court has nothing to do, your lordship.
Where is that? Who is the enforcing agency?
My lord, that is the Ministry of Corporate Affairs.
Where is the provision?
My lord, that has not been stated here in this, say, my lord, this, my lord, provision. And your lordship also see, my lord, what will be, my lord, the liabilities of the company, that is at Schedule 7, my lord.
No, okay. Assuming that there is a default,
Assuming, my lord, we have not defaulted, we have shown.
assuming
documents,
that there is a default, who will enforce that? Whether a criminal case has to be filed or some other authority is there. If some other authority is there, then you have a case.
Yes, my lord.
Otherwise not.
My lord, some decisions.
That you have to,
My lord, decisions say, my lord, it is the, my lord, the Ministry of, my lord, Corporate Affairs will enforce it. Because, my lord, they have to file the return. On the basis of the return, my lord, section 134 specifies that, my lord. On the basis of the return only, my lord, the authorities will find out whether, my lord, we have.
no, which is that authority?
My lord, because we have to file the return to the, my lord.
No, I want to understand. Section 135 imposes a corporate social responsibility, liability against corporate social responsibility of a company to the extent as provided in the section, 2% or something. Suppose a company default in complying with the,
That will be reflected in the return, my lord.
then who
Then
will
why not?
impose the penalty?
Because after the return is there, my lord, only the, is the, my lord, the Ministry of Corporate Affairs, my lord, who will impose that fine.
That point, if you can satisfy that there is a separate authority.
Now, first thing first, my lord, is there a criminal liability? There is no criminal liability.
No, they have approached the court for enforcing that liability. But if you can show that this is not the proper forum, there is some other authority under the Companies Act.
My lord, if I may place a decision on this, my lord. Of course, that is of my lord, Gujarat High Court. And my lord, it has relied on some decision of the Supreme Court. Paragraph
No.
10, my lord. Because,
Yes.
my lord, 135(7) was incorporated in 2020. That is, my lord, decriminalization. Earlier, there was, my lord, criminal liability. Paragraph 10, your lordship may kindly read,
Yes.
my lord. The position of law stands crystal clear from the aforesaid judgment. Evidently, the benefit of, my lord, referring to Supreme Court decision. Evidently, the benefit of decriminalization of the offense ought to ensure the benefit of the petitioner, in as much as the Amendment Act passed by the central government has decriminalized the punishment in cases pertaining to corporate social responsibility violations and reduce the consequences to imposition of penalty. And your lordship may kindly come to my lord section 454 of the Companies Act. Adjudicating officer. Section 454. Has your lordship got it, my lord? 454 says, my lord, adjudication of penalties. The central government may, by an order published in the official gazette, appoint as many officers of the central government not below the rank of register as adjudicating officer for adjudicating penalty under the provisions of this act in the
Yes.
manner.
Yes. Yes.
So, my lord, there is an adjudicating officer.
Okay. Yes, Mr. Water. This is a private complaint.
The private company and
Okay.
my lord,
Complaint.
individual complaint.
Okay, heard Mr. M.K. Chaudhary, London. Senior Counsel assisted by Mr. P. Bhardwaj, Learned Counsel for the petitioner. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Olimax Energy Private Limited, represented by its VP Commercial Shri Shobhit Niranjan, praying for impugning the order dated 6/8/2025. But this you can plead before the trial court.
My lord, I expected this, my lord. The question is, my lord, when there is no criminal liability, my lord, why should I go to the criminal court? My lord, there is no pleasure going to. My lord, why should one be sent to the, my lord, criminal court when there is, my lord, no criminal liability?
Order dated 6/8/2025, passed by the Court of London Additional Chief Judicial Magistrate Jorhat in CR case number 144/2025, whereby precognizance notice under section 223 of BNSS has been issued to the present petitioner. Stop. Learned Senior Counsel for the petitioner submits that the impugn order has been passed in the CR case number 144/2025, in which was registered on the basis of the complaint lodged by the respondent Shri Roop Jyoti Kurmi, wherein certain allegations were made against the present petitioner. He submits that the main accusation against the petitioner company is that the petitioner has not complied with the statutory requirement of its contribution towards what is CSR, corporate
Social responsibility.
corporate social responsibility. Learned Counsel for the petitioner submits that the requirement of contributing to against corporate social responsibility has been incorporated in section 135 of the Companies Act 2013. He further submits that if there is a default in complying with the state statutory requirement, section 135 clause 7 prescribes for only penalty. He further submits that the violation of section 135 of the Companies Act does not entail any criminal liability, and only imposition of penalty to the extent prescribed in the statute has been provided therein. He further submits that the penalty may be imposed only by an adjudicating officer or adjudicating authority appointed in terms of section 450. 454 of the 454 of the Companies Act. He further submits that that earlier the default in performing corporate social responsibility, liability against corporate social responsibility of a company was a criminal offense. However, same has been decriminalized. And in that, same has been decriminalized by incorporating section 135 of the Companies Act,
135(7), my lord. That I-
135(7) of the Companies Act. In support of his submission, he has cited a ruling of the High Court of Gujarat in the case of KHS Machinery Private Limited versus Registrar of Companies within bracket special criminal application within bracket quashing number 9563/2017. Stop. Contentions. Stop. I have considered the submissions made by learned senior counsel for the petitioner and have gone through the materials available on record. The contentions raised by the petitioners, learned senior counsel for the petitioner, seems to be, not seems to be, needs to be looked into. Hence issue notice to the respondent and call for the scanned copy of the records of CR case number 144/2025 from the trial court. The petitioner shall take steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable after 4 weeks. Stop. In the meanwhile, considering the submissions made by learned senior counsel for the petitioner as discussed in the foregoing paragraphs, as well as considering the fact that prima facie it appears on perusal of the provision of section 135 within bracket 7 of the Companies Act that there may not be any criminal liability that liability for violation of the statutory requirement under section 135 is only to the extent of imposition of penalty. Hence, further proceeding of CR case number 144/2025 shall remain stayed till next returnable date.
It is trial court. But the matter is tomorrow. If it is made online today, my lord.
Okay. Yeah, online. Okay.
I got 20. I'm highly obliged.
Yes, Mr. Vishnu.
Application under section 520 of DNSS. We have challenged a complaint case pertaining to the alleged occurrence that we have annexed, my lord, here in page number 21. My lord, what happened? An alleged occurrence took place on 20th of January 2021. 20th of January 2021, and this complaint case was filed on 12th of March 2024. That is virtually after 4 years. And my lord, it was filed before the learned Chief Judicial Magistrate Sri Bhumi.
who has transferred the case to the additional chief judicial magistrate for disposal. And the learned additional chief judicial magistrate, without following 356, my lord, has forwarded the application to the
Without following,
under provision without following 156 of the CRPC, my lord.
CRPC is not applicable.
It is an old matter, that's why I'm saying. Without taking any evidence or any hearing the informant or any structure of the informant, forwarded to the police station at Nilam Bazar to register a case. Nilam Bazar OC, when received it, found that there was no jurisdiction. So he has forwarded it to the Guwahati police, that is the Hathigaon. In Hathigaon, the OC has registered a case under 376 and 4 of the POCSO. The accused was arrested. The Honorable High Court has considered the bail of the accused. He was enlarged on bail. I have annexed the order.
You are on bail.
I am on bail. And now, my lord, the case has been charge sheeted. Now, our contention before your lordship is that the whole system, the whole
Okay, we'll examine.
Yes, sir.
was wrong, my lord, wrongly initiated. And on that point, I have brought my lord 4 judgments
No,
of
not today.
Uh.
We'll examine the matter.
Apex Court, High Court, our own High Court.
Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Ibadul Islam alias Abaduddin, praying for quashing of the
Okay. Charge sheeted.
quashing of the charge sheet as well as entire proceedings of, you are praying for quashing of entire proceeding.
Yes,
Entire proceeding of which
special case number 45. Special session case number 45.
where it is mentioned.
In the synopsis, it is there. First page.
Special session, special case number 45/2025. Pending before the Court of Learned Additional Sessions. Special Judge POCSO, Kamrup Metro. When is the next date fixed?
17/12. 17/12.
Stop. Let the notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice on respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 16/12/2025. Let also the scanned copy of the records of special POCSO case number 45/2025 along with the connected case, scanned copy of the connected case diary be called for this accordingly.
But till that returnable date. And the other.
Returnable date is before your fixed date. Your fixed date is 17.
Matter of stay would be considered next day.
You make the submission on the next day.
I have to wait for long to then. Anyway, I leave to you.
16. 16/20.
I please your lordship. It's a 528 application under 528 of BNSS, your lordship. Your lordship. For passing of the charge sheet and framing of charges, your lordship. Under order dated 11/6/2025, passed by the learned additional district and session judge FPC.
On what ground?
Your lordship. For passing of the charge sheet and framing of charges, your lordship. Under order dated 11/6/2025, passed by the learned additional district and session judge FPC. Your lordship. For passing of the charge sheet and framing of charges, your lordship. Under order dated 11/6/2025, passed by the learned additional district and session judge FPC. in session case number 90 of 2025.
On what ground you are seeking quashing?
Your lordship,
What are your grounds?
the present criminal proceeding, your lordship, is attended in a malified intention, your lordship. Institute only to wreak vengeance upon the accused petitioner and to force him under social pressure, your lordship. The victim and the accused petitioner is voluntarily connected through social media, your lordship. And that she is willing to share the personal information, your lordship. And your lordship, the
When is the next date fixed? Mr. What is your name? A.M. Siddiqui, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, issuing notice.
Yes, sir.
P. Bhattakur, learned additional public prosecutor. This application under section 528 of the NSS has been filed by the petitioner, namely Hiteshwar Deka, praying for quashing of the charge sheet as well as setting aside the order dated 29, setting aside of the order dated 29/9/2024, by which and you are appearing, approaching this court.
11/6/25 for framing of charges.
Order dated 11/6/2025, by which charges were framed against the present petitioner under section 376(1)/384/417 of the Indian Penal Code. Who is number 2?
Number 2 is the informant, your lordship.
Number 3 is the victim.
Number 3 is the victim, your lordship.
Here, my lord, son is the informant and victim is the mother, my lord.
Issue notice to the respondent number 2 and 3.
My humble submission before your lordship is to kindly call the TCR and until the disposal of this petition, your lordship, the proceeding may be.
When is the next date? Issue notice to respondent number 2 and 3. The petitioner shall take steps for issuance of notice upon the respondent number 2 and 3 by speed post within 7 days from the date of this order, returnable on 16th of December 2025. Also call for the scanned copy of the records of trial court along with the connected case diary, scanned copy of the connected case diary, list accordingly.
22.
May it please your lordship. I'm challenging to set aside and pass the first information report that was filed against me. Your lordship, FIR, your lordship. A trap was laid. However, your lordship, I was not aware of the trap. There is an allegation that I had demanded bribe amount, your lordship, but there is no acceptance on my part. I am granted bail in this case, your lordship. Your lordship may kindly peruse the FIR, which is at page 19. May I-
No, what ground you are seeking?
Exception is, with respect to a case under the Prevention of Corruption Act, your lordship, under section 7, it's important that there has to be a demand and acceptance of the bribe. In this case, your lordship, there is an allegation, there is a demand, but there is no acceptance. So until and unless there is demand and acceptance, your lordship, the Supreme Court has made it very clear that without those two, the case is not true. That is why I am challenging. Your lordship may kindly peruse, if your lordship may kindly.
What is the status? Charge sheet has been
No,
laid.
your lordship. Yes,
In,
The FIR was filed on
in-
20/10/2023, till date, no charge sheet has been filed, Your Lordship.
Don't get the instruction, madam.
So during investigation, it would be found whether there was a demand on acceptance or not.
In my
FIR need not to contain everything.
True, Your Lord. But in this case, Your Lordship, what has happened was, there was no acceptance at all. The trap team.
No, that would be found out by the investigating officer during investigation.
But there was no acceptance on my part.
Then why should we interfere?
No, Your Lordship, but there is a demand in this case is pending. And I'm due to retire after a year, Your Lordship. So that is my apprehension that because of the pendency of the case, I might have some trouble with when I retire, Your Lordship. That is why I filed this petition. Otherwise, I was waiting for the charge sheet to be filed with me.
Heard, Mr. We'll call for the case diary. Heard Mr. T. Devri, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, Shri Kobindra Rabha, praying for quashing of the first information report dated 20/10/2023, which was lodged by respondent number 2, on the basis of which Anti-Corruption Bureau PS case number 87/2023 was registered under section 7 within bracket A of the Prevention of Corruption Act 1988. So issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 16th of December. Let the case diary be called for.
On my lord,
Same 16 December,
yes, yes,
16 December. List accordingly.
Very grateful. Please, Your Lordship. This is a indication, my lord, for judgment of a complaint as well as the order taking cognizance insofar as the petitioner is concerned. The petitioner is a pharmacy, my lord, the proprietor of a pharmacy. My lord, a particular tablet was seized from his possession, my lord, along with another sample. That was found to be not of standard quality. My lord, I had cooperated with the drug inspector, my lord. I had followed whatever directions were given to me. However, my lord, I have been named in the complaint, even though the prosecution
Who will be representing?
my lord, it's a
Special-
district complaint, so PP, and there is another ground which I have taken, my lord, is that there is no PP appointed in the court of the CJM, of the learned CJM, my lord. So therefore, there cannot be any prosecution in the court of the learned CJM, insofar as this particular case was concerned. Further, my lord, the health department, my lord, we have served it on, my learned friend is there. And the complainant is the inspector of drugs. If my lord comes to my lord,
You are representing respondent number 1 and 2. And 3, the inspector of drugs.
he doesn't, because the
You can
complaint was.
replace.
He was inspector.
I can appeal. Your Lordship.
You can represent.
No,
Yes.
it's my lord, it's Page 45. That is the application or the statement against me in the complaint, my lord. This starts at my lord, page 43, the complaint.
Now,
Relevant-
charge sheet has been, no, complaint case, complaint.
Same.
Okay. What is this stage?
My lord, it's for appearance. It's fixed on 26th of November. My lord, that I have cooperated with the investigation. That is stated in the FIR, in the, sorry, my lord, the complaint itself and the documents annexed to the complaint. Page 45, if my lord kindly has. For a moment, my lord.
Yes.
paragraph 6, my lord, that after receipt of the said adverse analysis report, a letter right number so and so dated 27/24 enclosed as annexure PH along with a copy of the said adverse analysis report was sent to the firm Messrs ZSL Agencies, Babupati, ward number so and so, Sipsagar, through by hand, and in response to the same, the said firm replied by letter number nil dated 11/7/24 enclosed as annexure PI, along with the purchase invoice of the said drug in question. The firm has disclosed that the said drug was purchased from the firm Messrs Symbiosis Pharmaceuticals Private Limited, Kala Am District, so and so. Himachal Pradesh.
What is the acquisition? Acquisition.
There were two samples taken, my lord.
Two samples?
Two samples of two drugs taken, my
Okay.
lord. One was of Montelukast and levocetirizine, that allergy drug.
Okay.
That was found to be not of standard quality. Not
So-
spurious, not adulterate.
Not of standard quality. So the offense is under what provision?
Offense, my lord, the cognizance has been taken under 22(3). My lord, I've annexed those particular sections, my lord, extracted those sections. 22(3), 27D and 28A of the Drugs and Cosmetics Act. If my lord for a moment comes to page, my lord 12, my lord, I have extracted the sections.
Now, what is your contention?
My contention, my lord, I have produced all the relevant documents. Therefore, there is no allegation, even in the body of the complaint, there is no allegation against me that I have willfully obstructed. The offense, my lord, is willful obstruction,
Which one? Which offense?
22(3), my lord,
Where is
page
22?
12, my lord, if my lord comes to.
Yes.
22(1) is the power of inspector. Then 22(1), subject to the provisions of.
So is there any specific mention that you are charged only against offense under 22(3)?
They have simply put my name, even though the sanction to prosecute by the government is given against the manufacturer. They have enclosed it to the complaint, my lord, page 75. Page 75. The drugs controller has permitted the inspector to prosecute only Symbiosis, not me, the manufacturer. The documents annexed show that I have complied. The request was to provide the details of the drug purchase. I produced the invoice that Lordship has read in paragraph 6 of the complaint. There is no other statement against me. It is only the manufacturer who has not complied. There were 3 notices sent, 1 notice followed by 2 reminders. The manufacturer did not.
And in
respond.
the complaint, there is no accusation against you.
No, nothing.
Okay, yes. What you have to say?
Yeah, what if I take the matter on Monday, your lordship? Mr. Big Over was supposed to do the matter, your lordship. This is the court, your lordship.
Tomorrow, my lord, it is no, tomorrow,
For tomorrow, your lordship.
No, let it be on Monday. When is the next date fix?
26. my
It can be on Monday. Yes, you may appear through VC. Heard Mr. P.D. Nair, learned counsel for the petitioners. Also heard Miss, what is her name? A. Das, learned standing counsel,
I'm appearing on behalf of Big Over, your lordship.
appearing on behalf of Mr. B. Gogoi, standing counsel, Health and Family Welfare Department, Government of Assam, appearing for all the respondents. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Mr. Latif Khurshid, impugning the praying for quashing of the criminal proceeding qua the present petitioner in CR case number 1/2025 pending before the Court of Learned Chief Judicial Magistrate, Sipsagar. Stop. Learned counsel for the petitioner has submitted that the state of Assam has filed a complaint case which was registered as a complaint case before the court of learned chief judicial, before which court? Chief Judicial Magistrate Sibsagar, which was registered as CR case number 1/2025 under section 18 within brackets small a within brackets small I /18 capital B /18 small a within bracket small Roman 6 read with section 22 within bracket 3 of the Drugs and Cosmetic Act. Along with section 22 within bracket 3, section 27 within bracket D, section 28 capital A of the Drugs and Cosmetic Act 1940. Learned counsel for the petitioner has submitted that the complaint in the complaint filed by the respondent, the basic plea is that during an inspection by the drug inspector, that is respondent number 3. What is ZSL agencies?
My pharmacy.
In the pharmacy, namely Messrs. ZSL agency belonging to the present petitioner. It was found that where are the name of the drugs?
My lord, page 6, my lord, I put a table.
Found that
Second one was found to be a lot of seven.
that the drugs, namely page number 6, the second column, I have marked it as A. Montelukast sodium and levocentrizine hydrochloride tablets were not found up to this,
Not of seven.
not of standard quality. Learned counsel for the petitioner submits that the acquisition is mainly against the manufacturer of the said drugs, and as the proprietor of the pharmacy within bracket aforesaid firm, the petitioner had fully cooperated during the inspection carried out by the respondent number 2 and also thereafter. He further submits that in the complaint petition, no accusation against the present petitioner has been made under section 22 within bracket 3 of the Drugs and Cosmetic Act 1940, and therefore no case has been made out against the present petitioner in the said complaint case, and hence he prays for quashing the proceeding of the aforesaid complaint case for the present petitioner. On the other hand, Ms. M. A. Das, learned counsel appearing on behalf of Mr. B. Gogoi, prays for taking up this matter on Monday, so that the standing council may respond to the submissions made by learned counsel for the petitioner after taking necessary instructions in this regard. Hence, let this matter be listed again on 17th of November.
It's also there.
22-3. Okay. The pity learned एक line ऊपर डाल देना. Learned counsel for the petitioner also took the plea that the prosecution sanction required to initiate a proceeding under section 20 under the Drugs and Cosmetic Act 1940 has also not been obtained in this case
Against the petition.
against the present petitioner. Listed.
24.
Yeah, please, your lordship. Page 15, my lord, impugn order, my lord. But I have come only for modification of my lord condition, my lord. That was passed by Planet Chief Judicial Magistrate Baksha, my lord. Page 15. But my lord, 3 lakh bank guarantee was my lord imposed, my lord. This is not possible for me, my lord, because the vehicle was.
What are you impugning?
My lord, page 15, my lord, order, my lord. By this order, my lord, my vehicle was granted Dhimma, my lord. Imposing condition that, my lord, I have to furnish bank guarantee of rupees 3 lakhs. And my lord, so my lord, this condition modify, my lord, because my lord, I am not in a position to give the bank guarantee, because my lord,
Okay.
the vehicle was purchased, my lord, on finance, my lord.
Do you have any judgment? The law says that bank
Yes.
guarantee.
Yes, my lord. That is
Bank
my lord,
guarantee.
and your lordship
And the
already.
value of the vehicle,
dealt with
my lord, is
one matter,
18
my
lakh 65,836. Now he cannot even provide a bank guarantee of rupees 3 lakhs.
Value of the vehicle is
18 lakh 65,836.
But my lord, 3 lakhs was paid at the time of purchasing, other my lord by bank, my lord, financial, my lord. Other orders are by coordinated, my lord. I have
what is to be done?
Yeah, otherwise, my lord, as per the provision of the act, my lord,
Now provision has been diluted by the judicial pronouncement.
Because my lord, what is the purpose of
leave it to your lordship.
that provision, my lord, to secure, my lord? So I will follow, my lord, any condition, my lord. Personal bond, I am ready to give, my lord.
No, but how to overcome the statutory requirement?
Because your lordship already, my lord, observed, my lord. Similar matter, my lord.
Okay. Heard Mr. S.H. Sorry. S.H. Sikdar, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor. What is your submission, Mr. Bhattakur?
Otherwise, my lord,
That statute provides bank
yes.
guarantee.
Prospect, because in considering the earlier my lord orders he has annexed, my lord, your lordship, otherwise,
Okay.
provision is, my lord, specific, my lord, that.
Also heard Mr. P. Bhattakur, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, namely Sirajul Islam, impugning the order dated 15/10/2025 passed by learned Chief Judicial Magistrate Baksa Musalpur in Baroma PS case number 64/2025. The petitioner is by the said order, the custody of seized vehicle bearing registration number AS 25FC 7029 was granted to the petitioner. The petitioner is only aggrieved by the impugn order to the extent that it has directed the petitioner to furnish bank guarantee of rupees 3 lakhs, which learned counsel for the petitioner submits that the petitioner is the owner of the seized vehicle and he has purchased the seized vehicle on bank finance by paying regular EMIs. Hence he submits that by that it would be very cumbersome on his part to comply with the condition imposed by the trial court of furnishing bank guarantee of 3 lakhs. For granting Jimma of the said vehicle to the petitioner. Learned counsel for the petitioner has submitted that the Jimma of the aforesaid vehicle was granted to the present petitioner as same was no longer required for the purpose of investigation. Quote paragraph number 9. 9 from criminal petition number 244/2025. Record being here. Quote paragraph number 10. Quote para 11, 12, 13. Fourteen. When was the impugn order passed?
15/9/20.
15/10.
9. One second.
It appears that though the order of grant of Jimma of the vehicle was passed by the trial court on 15/10/2025. However, due to financial constraint and due to inability of the petitioner to furnish the bank guarantee, the vehicle could not yet be given in Jimma in person to the direction of the trial court. Court para 17. You furnish a bond of rupees, how much?
3 lakhs, my lord, considering the value of the, because bank guarantee he has not submitted, so 6 lakhs. maybe.
Sorry, 6 lakhs, 7 lakhs.
Yeah.
This case is accordingly disposed.
Hello, hello.
Putul, Gaon Panjan.
It please, the decision appears under section 483, my lord. FIR is at page number, lordship 14, my lord. Operative in my lord, page number 16, my lord. Now, I'm here, my lord, trial is going on, my lord. Now I am before your lordship on the ground of, on the condition that when I was arrested, ground of arrest was not intimated. I have annexed, my lord, arrest, my lord, issued under section 47 and 48, lordship. And my lord, prosecution witness has already been completed in the trial. my
Also,
lord. Yes, lordship. Now defense, I have to submit the, use the defense witness, lordship.
we'll issue notice to the victim. Heard Mr. G. Alam,
Yes, sir.
H. Rahman, learned counsel for the petitioner. Also heard Mr. B. P. Bhattakur, learned additional public prosecutor. This public prosecutor issue notice to the respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 2nd of December,
But in the meantime, my lord, scan copy of L.
2nd of December. Stop. Let the scan copy of the trial court record as well as scan copy of the connected case diary be called for. Let this case be listed accordingly. Yes.
My lord, his IO has detained my client for 40 days and he had detained me for another 2.5 hours.
So you also want some relief.
Absolutely, my lord. That's precisely.
So I'm ready to grant relief to you, not to your client.
All the same, my lord, I am the representing him. So like,
Okay.
my lord,
What is your case?
some, these bats, you were found catching some bat. 41 days he is in custody, man.
Bats is in which schedule?
They
My
are
lord,
saying
Schedule 2, my lord.
Schedule 2, they are saying Schedule 2, this fruit bat, my lord. They found,
What is schedule 2?
these are endangered
Endangered.
birds and all, my lord. Mammals. These are not, my lord, because this very amendment, the Assam amendment was brought into to tackle the menace of rhino poaching. But now, my lord, because of that, my lord, even for all these bats and some birds also,
They have to be preserved.
my lord, they're finding it difficult to preserve human beings, my lord. Seen what had happened in Delhi, my lord.
Okay. No, what is your case?
No, my lord, my case is that 41 days he's been in custody.
Wh-
He was being interrogated, not even no further police remand is sought for. So, my lord, for the purpose of investigation,
Why are you hunting wild bats?
no, my lord. Some people have crazy fashions, my lord. They go for bat and all.
Then they have to face
They
consequence.
had, my lord, 41 days. It's not that I have not come within 1 day or 2 day or 3 days, my lord. 41 days. 41 days was in it. No further application for custodial interrogation, nothing. I'm on bail, my lord. Whether he has actually done it, not done it, my lord, that my lord,
Yes, do you require his further
is redundant.
custodial detention?
So, my lord, kindly have my lord offense report, because my lord, 14 numbers, my lord. It is not a 1 or 2 numbers, my lord. It is my lord illegal trade and my lord.
When can you produce the offense?
My lord, 24th, my lord.
Fourth, it will be perhaps statutory period, my lord.
No.
Give a short date.
Short date, my lord.
Haju, the handshake distance.
Hmm.
Haju, it's near your native.
Heard Mr. M. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned special public prosecutor of wildlife.
On 17,
18th,
18,
Said 17.
17,
17 you can bring,
18, my lord.
then, okay, 17.
Man,
Let the offense report be called for. The learned special public prosecutor is requested to produce the offense report on the next date, please. Let this case be listed on 17th of November. Yes. None appears for the petitioner on call. Let this matter be listed again on 19th of November.
Okay, is your lordship. Proceed, 528 application. Tuning the charge sheet lordship which has been laid against the petitioner. The draft of the Indian charge sheet lordship could be pleased to find that page 19.
Yeah, sheet,
Section 85 of PN.
what is 85?
It's a cruelty by husband and
498A.
page 19, which I'm referring, the extract of the charge sheet lordship, the allegation against the petitioner. Nowhere in the, may I read the contents lordship?
No, what is your contention?
Nowhere, while laying down this charge sheet, nowhere it has mentioned that as per the guidelines of Manav, Manav Adhikari versus Union of India, 2018.
What
So
is that?
Their SHIPA guidelines have been framed. It's sort of for, this is my basic contention, that is the charge sheet has been laid by misusing the power, and that is rampant misuse of power. So that has been done without following the due process of law. The due process of law is there. This before filing, there has to be a this matter has to refer to the Family Welfare Committee, and thereafter they can, if they find thereafter also that exists lordship, they can file. That is their lordship. So that has been not followed lordship. Straightway they have filed even petitioner had to go for bail also, because even that cooling period also not granted to him. They were constantly searching.
Which
So that has
which guidelines are not followed? You have that case. You are basing your case on that case. That is not with you.
That-
When is
Their
it?
lordship guidelines has been issued that this comprehensive guideline.
No,
is
unless you
that-
place that case. When is the next date?
2018.
Heard Miss T. Som, learned counsel for the petitioner. Also heard Mr. P. Botakur, learned additional public prosecutor. This application under section 528 of BNSS has been filed by the petitioner, namely Sandeep Burman, praying for quashing of the charge sheet number 31/2025, which was filed in the PRC case number 735/2025, showing the petitioner as an accused under section 85 of BNS. Learned counsels for the petitioner submits that the main contention of the learned counsel for the petitioner is that charge sheet in this case was filed in violation of the guidelines laid down by the apex court in the case of
Union of India.
Manav Adhikari versus Union of India, reported in 2018,
443.
10 SCC 443. So let the notice be issued to respondent number 2 by speed post as well as by usual mode. The petitioner shall take steps for issuance of notice upon the respondent. Number 2, within 7 days from the date of this order, returnable on 16th of December. Let also the scanned copy of the records of the trial court as well as connected case diary be called for, list accordingly.
Yeah, pray for him.
This case is fixed before your next day.
Then let there be an observation. Interim.
No observation.
Otherwise, Lordship.
Otherwise what? Otherwise nothing will happen. No.
Right, Lordship.
May I please, my lord? It's a criminal petition, my lord, under 528, which challenged, my lord, the NBW orders of the London Trial Code. Now, upon filing the charges, my lord, are 365, 376, read with section 4 of POCSO. My lord, may kindly come to the page number 23. So this was the very first time, my lord, upon submission of the charge sheet, wherein I was being shown as an absconder. So London Trial Court, on the basis of that remark, have directly issued NBW against me without issuing any summon or any bailable or anything. And thereafter, from page number 23 to 30, the subsequent NBWS has been forwarded. And my next date is on 26/11/2025. My limited prayer will not that let this be quashed and allow me to appear before the trial court to appear and file a bail plea. Charge sheet was submitted.
Yes, let him file an appropriate application before the trial court.
Let this be quashed, my candidate.
NBW may be kept in a bench till date.
Okay. Heard, Mr. What is your name?
SS Ahmed.
SS Ahmed, learned counsel for the petitioner. Also heard Mr. P. Thakur, learned additional public prosecutor. This application under section 528 of BNSS 2023 has been filed by the petitioner, who is aggrieved by the orders dated 29/7/2024 and subsequent orders passed by the Court of Learned Special Judge Vilasipara, whereby non-bailable warrant of arrest and were issued against the present petitioner. Learned counsel for the petitioner has submitted that the petitioner has been shown as an absconder in the charge sheet laid against him in the aforesaid case. In which case? In
My lord, it is special POXO case 26/2024.
in special POXO case number 26/2024, pending before the Court of London. Special Judge Bilasipara. He submits that it is a settled proposition of law that even if the name of name of an accused is shown as an absconder in the charge sheet, the trial court should, at the first instance, issue summons and should not go for issuing non-bailable warrant at the first instance. Whereas in the instant case, the trial court, on receipt of the charge sheet at the first instance itself, issued non-bailable warrant against the present petitioner. He further submits that the next date of the aforesaid case is fixed on 26/11/2025, and the petitioner is willing to appear before the trial court and cooperate in the trial. However, as non-bailable warrant is pending against him, he seeks some interim protection from the court. So, learned additional public prosecutor does not raise any objection regarding grant of interim protection only for the purpose of appearing before the trial.
Only till my lord, his appearance before the trial.
Date. Yes. Considering the submissions made by.
Direction, my lord, that my bail plea may be considered on merits.
That will otherwise be,
I may be allowed to file bail.
no, don't interrupt. The. What was the last name? Considering the submissions made by learned counsel for the petitioner and considering the fact that the petitioner is willing and ready to cooperate in the trial, this criminal petition is disposed of with the direction to the petitioner to appear before the trial court, that is the Court of Learned Special Judge Bilasipara, in special case number 26/2024 on the next date fixed, that is 26/4/2025. Stop. To facilitate his appearance before the trial court on the said date, the operation of non-bailable warrant of arrest issued against him shall remain suspended till that day only. On his appearance before the trial court, he may pray before the trial court for any relief to which he is legally entitled to. This.
May I please? My lord, working of the criminal proceedings, my lord. Here, my lord, first sheet has been laid, my lord, for offense of section 376, my lord. And date is fixed for appearance on 15th. We have filed this application, my lord, because there is a settlement between the parties. To that effect, my lord, informant side, we have appeared. And they have filed their, my lord,
Who is the informant?
Informant is the my lord victim. He is the measure, my lord. Both are teachers, my lord. Petitioner is working in a government school, my lord, and she is working in a my lord private school.
They had some relation, my lord, then my lord, due to certain misunderstanding, my lord, this affair was lost, my lord. Subsequently, my lord, on being filed this petition, my lord, he has also appeared and filed her, my lord.
Why it has been compromised?
My lord.
Why?
Case is from Guwahati, my lord.
No, why it has been compromised?
Because, my lord, they want to settle in their both of their lives, my lord. He also want to settle, my lord. There is a marriage proposal.
Whether
also.
such cases may be compromised.
Yes, my lord, some decision of the, my lord, Supreme Courts are there, and our high courts are also there. Relying on those decision, my lord,
Which decision you?
I am just, my lord, before your lordship, my lord.
So Supreme Court's judgment.
Yes, my lord, this is the last decision. 2025, 14 July. my lord. And our high court also, my lord, two decisions are there, my lord. In this case, my lord, both of them are married, my lord.
In the case cited by you, what are the facts?
The both petitioner and the informant, they are married in this case.
In the
This
Supreme
decision.
Court case?
Yes.
That is not applicable to.
Yes, but our high court decision is there, my lord. He was married to a different person. That is our high court decision, my lord. 14 months. And
No, our High Court decision is not, ordinate bench judgment is not binding on this court.
yes, my lord. But the only thing, my lord, whether any fruitful purpose will be served or not, my lord. Because the victim is now not interested, my lord.
No, what are the criteria for quashing a case involving 370?
Yes, my lord. These are the decisions, my lord, where it is stated that whether there will be fruitful purpose will be served or not, my lord. Because if she doesn't come to, my lord, goes before the court, my lord,
No,
unnecessary-
there are leading cases
my lord.
which has settled the law. What are
Yeah,
those?
their decisions are also that all,
Show.
my lord, this 376 offenses, my lord, usually, my lord, it is not, my lord, permissible to, my lord, for settlement and all,
When it is permissible,
my lord.
when it is permissible.
My lord, because as, my lord, both of them, my lord, they have come for a settlement.
No, you show the authority on which,
In these decisions only, my lord, it has been mentioned, man, that whether
Hmm.
there will be fruitful purpose will be served or not, my lord. Whether, my lord, valuable time of the court will be wasted or not, my lord.
in the latest decision which you have cited, which para you are relying?
My lord.
Yes, Mr. Bhattacharya.
There are 5, my lord. It can always object from in, my lord, in case of settlement also, my lord. And that my lord, section 376, the remand of complaint, although my lord, settlement, my lord, there are 5, it is there, my lord, Supreme Court decision. There are 5,
But the
6,
Supreme Court's decision may not be applicable because parties here got married.
Here, the criteria is, my lord, the given, my lord. There are 5 lawsuits that can be looked into, my lord.
Yes. There are 5,
Yes, my lord. It is brought to our attention that both
then
parties.
the emphasis on marriage and residing together and
Then, my lord, at the outset, we recognize that the offences under section 370 IPC is undoubtedly of a grave and immediate nature.
Ordinarily, quashing of proceeding involving such offences on the ground of settlement between the parties is discouraged and should not be permitted lightly. However, the power of the court under section 484 CRPC to secure the ends of the state, I want that money, is not constrained by a rigid formula and must be exercised with reference to the facts of each case. I am on that mind.
When is the date? When is the next date?
15th is the date of appearance, man. Day after tomorrow.
What you have to say?
Lordship, I have already stated my affidavit, Lordship, because I am getting Mary's proposal, Lordship. And due to the Lordship misunderstanding, I have lost this FIR at that point of time, Lordship. We had a relationship, Lordship, back then 2020. And suddenly our relation break down and thereafter, Lordship, we had no contact and all, and out of Lordship frustration, I had lost the FIR, Lordship. And now, Lordship, was because I'm also already settled in my life, Lordship, after these two years, Lordship, and I'm getting proposal, many proposal letter, Lordship. I have already entered into a settlement agreement with the present petitioner, Lordship. I have annexed in my affidavit at page 46, Lordship. And I've stated in my paragraph 5, Lordship, at page 43 of my affidavit, Lordship. Paragraph 5, Lordship.
Yes, Mr. Bhattabhar, anything else?
Otherwise, my lord, Supreme Court is also in arguing, my lord, Lakshmi Narayan and other decisions, my lord, already, although in some non-compoundable offences also, my lord, case can be settled between the parties. But regarding some heinous offences.
What is the citation of Lakshmi Narayan?
My lord,
Lakshmi Narayan, that
at
means
this point of time, not with me, but I can.
okay, tomorrow delivery. Third, Mr. B.M. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. P. Bhattakar, additional public prosecutor, as well as Mr.
As to the Lordship.
S. Sutradhar, appearing for problem number 2. Let this matter be displayed on 14th of November for delivery of judgment. Tomorrow I will pass that.
Tomorrow. I'm obliged.
May I speak, your lord?
Okay. Yes,
Matter relating to Wildlife Protection Act. And case has been registered under section 9, 39, 49B and 51 of Wildlife Protection Act, Lordship. The allegation is a pangolin has found in the possession of the accused petitioner, Lordship. And he has been arrested on 26/9/2025. He is behind the bar for 48 days. Lordship. The investigation is over, Lordship. Pangolin has been recovered, so further investigation is not required.
yes.
Lord, investigation, my lord, still going on, my lord. Then, my lord, kindly, my lord, may be allowed to place the offense report, my lord. Because it is a schedule 1 animal and
Yes. Third, Mr. What is your name?
Yeah, Ali, Lordship.
Ali Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Special Public Prosecutor, Wildlife. considering the nature of acquisition made in this case, let the copy of offense report be called for on or before next day with short date.
24th, my lord.
Let this matter be discussed.
60 days. 24.
59.
60
It
days.
is from Dhubri, my lord. That's why, my lord, I am.
No, lordship,
From
his
Dhubri.
record is from Borbata Road. The client is from Dhubri, but the place of occurrence is Borbata Road.
21st.
Lordship.
21st, my lord. Have a look, my lord. My lord, 21st.
21st November.
Obliged.
Is a lordship. Your lordship, charge sheet has been Indian lordship. Before your lordship takes up the charge sheet, may I pray to take your lordship the additional affidavit that has been filed lordship, stacked with the record, starts from page 26 lordship.
Yes.
Dear Lordship, I have annexed certain document. Petitioner 1 is a man of 73 years old. He is a president of a political party, Assam Gana Parishad Lordship, within the Lamding Zone Lordship. And petitioner 2 is his son Lordship. Dear Lordship, the informant is a dealer of a two-wheeler motorcycle lordship, and even petitioner also having a sector to run a two-wheeler which is running in the name of Gayatri Traders Lordship, Gayatri Motors, and as well as MP Traders Lordship. Those documents I have annexed Lordship. It starts from first, annexure 3 is the document pertaining to his presidentship lordship, that he is the president of Assam Gana Parishad.
What is the acquisition?
Acquisition, that is the here the applicability of the sections which has been submitted by the prosecution, that is under question lordship. None of the section that lordship would be pleased to first lordship may kindly take up page 15 lordship. Page 15 is the
Completion of the investigation. Charge sheet has been
Perfect,
read.
Your
Your
lordship,
case is
kindly-
that the sections are not
Lord,
attracted. You
Yes,
take
Lord.
this plea at the time of discharge.
Yes.
but this proceeding is entirely lordship, a man of 73 years old, nothing is there in the case lordship. They have filed the charge sheet without anything lordship. That is question here lordship, the veracity and legality and propriety of the proceeding lordship. Nothing attracts lordship. That the affair is, affair would go to show that what material was there lordship. Nothing lordship. May I, for a moment lordship, may I take your lordship to the affair, which has been culminated to the charge sheet lordship, that page 15 lordship. For ends of justice lordship, may I take your lordship to that page 15 lordship? May I read the contents lordship?
Yes.
I, Samkot so Om Prakash Suras, resident of Lamding, Assam, would like to inform you that I am the owner of MS Auto Center, TVS dealer Lamding. I bring to your kind attention that Devjit Pal, locally known Babu Pal, and Mantos Pal, resident of Lamding, have had a conspiracy by creating fake email IDs in the name of our customers without their consent and knowledge, and lodged false and fabricated complaint against my dealership before various forums across the country to malign reputation and cause financial harm to my business since 1 year ago. The said issue is further cleared when many of the customers, after knowing about the filing of false and fabricated complaints in their name, have withdrawn complaints from the concerned authority. The accused persons have also threatened me and my staff, namely so and so, with their consequence, and demanded for ₹5,000 extortion against sale of each vehicle in order to stay away from causing any hamper in my business. I have doubt.
Here clear accusation is made.
Yes, sir.
No, Lordship, no, when I have charged 5,000, where I have no date, nothing has been mentioned, Lordship.
That will be find
Absolutely,
out
Lordship,
in,
this is a consequence when an FIR 160 that I have mentioned, even the charge sheet also reveals that 160, the petitioner one was taken into custody in connection that during that period, Lordship, this FIR taking advantage to frustrate the bail and to extend the date of detention, this FIR was filed, Lordship. But very whimsically, Lordship, without going to the deep of investigation, this impugned. So now this proceeding need to be quashed, Lordship. So may I pray, Lordship, this man, at least this man is a 73 senior politician.
age is not a
appearance-
factor.
His appearance be dispensed with, at least for him, Lordship, but not for his son, Lordship.
Pray before the trial court
Yes.
for dispensing. We'll make an observation that that may be.
In
considered.
the meantime, Lordship notice may go. That
Your
observation.
Lordship may kindly come to page 22, my lord. Here there are two petitioners, one Montus Pal and Devajit Pal, my lord. Page 22, first, my lord, already the allegation is there in the page 22 of the petition.
Yes.
Paragraph 2, my lord. This is, my lord, regarding the allegation, what is there in the FIR. It has been alleged that two persons, namely Devajit Paul and Montus Pal, they are the petitioners here in this petition. Both residents of Lamding had created some fake email IDs and using the same submitted false and fabricated complaints before the district transport office and other concerned authorities against his dealership. They also demanded rupees 5,000 from him connection with the sale of vehicles from time to time. Thereafter, your lordship may kindly come to my lord. Last my lord, fifth paragraph, my lord. During the course of investigation, the complainant and the witnesses were examined and their statements were recorded under 161 of the CRPC. In the meantime, in connection with the Lamding PS case number so and so, several documents containing information of 95 customers of TVS Motors, 95 customers, my lord, along with 10 blank sheets affixed with revenue stamps were seized. It was revealed during the investigation that the accused persons were involved in extortion by creating fear through false and fabricated cases. Since the accused Devajit Paul was found to be absconding, so my lord, Devajit Paul has not cooperated
Coming
during
to
the
that.
investigation.
Coming
He
to
could
that.
not be arrested. Therefore, a prayer was made before the court for issuance of non-bail.
Absolutely.
So, my lord, in this case, after completion of the investigation, already search is submitted, my lord, finding sufficient material against the accused persons. Search is yet to be framed, my lord. So, my prayer before lordship, considering all these allegations and the finding of the, on the basis of the finding of the investigation, also they are reflected in the search sheet. So, this is not a fit case, my lord, at this stage, my lord,
Lord-
for
Lordship, may I please, Lordship?
passing any.
So for the contention regarding absconding, but this petitioner, the second petitioner, he is in connection to both the cases, they are on bail, Lordship. They granted bail by this honorable court only, both of them. One granted privilege of the regular bail, other granted privilege of the PRS bail. They were granted. No one is absconding here. That is also a impartial, partial lordship investigation. That is why, Lordship,
Where is the bail order?
bail order that I have mentioned, but I have not annexed to this application. I mentioned in my petition.
When is the date?
Date is, Lordship, 29th of November, Lordship. 29 is the next date, Lordship. I'm only worried about this man. He's having heart issues, Lordship.
You pray
Have
for
I-
the
have I-
appropriate bail.
That observation meanwhile, Lordship, notice maybe issued absolutely no case, Lordship. Political rivalry and the business rivalry. That is why, Lordship, I have annexed all the documents. They are having.
Apart from submitting that there is no case, you are unable to submit anything specific. Apart from submitting that,
No section, 1 year ago. They are bringing an allegation of 1 year ago. Of where it is sustainable, Lordship.
is there any bar?
Lordship has to be, they have to, there has to be an explanation regarding the delay, Lordship. Where is that explanation, Lordship?
Can,
1 year, they were silent for 1 year there. Only when this 160 case has been lost, where this petitioner one has been, was arrested, and then this case 164 was lost against this petitioner, these two petitioner. Lordship, absolutely taking the abuse of the power, Lordship. So may I pray at this stage? I'm very much agreeable with your Lordship's this. If your Lordship gives an observation that there is painting, and in the meantime, notice may be issued to the respondent, let him come and in the record also,
Yeah.
record also
Let
will
them
go
first
to.
place, my lord, all these materials at the
record
time of
with
pending of charge, my lord.
Lordship,
If
the
my lord-
the material will definitely suggest with that. If your Lordship will find those
you need
material-
not to say many things, unrelevant thing. If you say, submit a relevant point, then you need not to say many
Yes.
things. Your submission is that there is a delay in lodging FIR, therefore the allegation is not believable. That cannot be gone into in 528.
That ground I have not taken, Lordship, I have taken the manipulate, whether those sections are attracted in the present case. Lordship.
Heard Ms.
That is the
Case-
main ground
Case
here.
of Learned Counsel for the petitioners. Also heard Mr. P. Thakur, Learned Additional Public Prosecutor. This application under section 528 of BNSS has been filed by the petitioners, namely Mantosh Pal and Devajit Pal, praying for quashing of the criminal proceeding of which case? PRC case number 656/2024, which arose on the basis of FIR lodged by respondent number 2. Learned Counsel for the petitioner has submitted that though the charge sheet has been laid against the petitioners under section 120B/389/420/468/4506 of the IPC against the petitioners. However, no materials has been produced, the prosecution side has failed to make out any case against the said provisions. She submits that in support of her submission. No, in support of her submission, she has placed on record certain documents filed by the petitioner along with the additional affidavit. He further submits that though both of the petitioners are on bail granted by the which court?
This honorable court.
This court. However, it has been stated in the charge sheet that who is on
No one absconding, Lordship. In both the cases, bail has been granted.
but in charge sheet it has been stated,
Yes, Lordship. Wrong statement, Lordship.
charge sheet they are shown as an absconder. She further submits that the petitioner number 1 is aged about 73 years of age, 73 years, and therefore is during the pendency of this criminal petition, the personal appearance of the said petitioner before the trial court may be dispensed with. She further submits that on the grounds stated by the petitioner in the criminal petition, the petitioners have prayed for quashing of the aforesaid proceedings. On the other hand, learned additional public prosecutor has objected to the prayer, objected to the issuance of notice in this case and submitted that after lodging of the FIR by the respondent number 2, alleging that both the petitioners have indulged in extorting rupees 5,000 each from each of the prospective purchaser who purchased the vehicles from their firm. He submits that in this regards, the investigating officer has collected documents concerning 95 customers of TVS Motors and also examined witnesses from which it is claimed that both the petitioners have indulged in extortion by creating fear of lodging false and fabricated case. Stop. After considering the submissions made by learned counsel for the petitioners, learned counsel for the parties, this court is inclined to look into the contentions raised by the learned counsel for the petitioner, hence issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 18th of December 2025. Let also scan copy of the trial court record as well as connected case diary be called for from the trial. Stop. As regards prayer of dispensing with the personal appearance of the petitioner number 1 in PRC case number 656/2024, the said petitioner may approach the trial court and may pray for the same said relief, which shall be decided by the trial court on its own merit. Let this case be listed again on 18th of December, 1812.
Hello. Hello.
Your Lordship, FIR, Your Lordship will find at page 12. Here, facts of the case is that police on receiving and secret information, they went to the ISBT and they recovered some contrabands from the bus. Now what they did, Lordship, after recovery of the contraband, Lordship, they arrested the driver and handyman of the bus who were not present, in fact, in the place of occurrence. Subsequently, they were brought from different places and they were arrested. It didn't mention in the FIR itself. Page 12.
Who are you?
I'm the driver and handyman.
Okay. Where is the affair?
Page 12. Where it,
The recovery was made from a parked way.
yes, from the bus which was parked in ISBT, Lordship. And driver was at Hatigaon. From there, he was called by the police. He came and subsequently he was arrested. Now, how they have linked these present petitioners with the those contrabands that my learned friend can place before the court.
Because I have the copy of 161, Lordship, those documents, I do not find anyone implicating the present petition.
Charge sheet has been laid.
Charge sheet has been made.
Why the trial court rejected?
No, my bail application was pending before this honorable court. This honorable court directed to update the case diary, and in between they submitted charge sheet, Lordship. So case diary was called during pendency of my bail application.
Now the scan copy of the
Scan
case.
copies of the records are there, statements
there.
are there. And Lordship, may I kindly say how they have connected my clients with the contraband, Lordship? I do not find anything subject to what my line of fence is before you.
Where is the FIR?
Page 12.
What is your name?
Mine, I am appearing for Lordship, that Uttam, that accused number 3 and 1.
Who is Shahabuddin?
Shahabuddin is the driver. Uttam is a handyman. Sofiur is handyman. And they suspect that Ziaur Rahman is supposed to took over those contraband.
I'm for petitioner number.
No, just him. Mr. Ahmed,
Okay.
read the FIR.
I would like to report that at 6 AM, source information was received that narcotic destined for supply in Kamrup and other areas, it would be transported from Aizawl to Guwahati in bus number so and so by the drivers and handyman of the bus in lieu of huge amount of money to be paid the vendees of the narcotics, namely one Afaz of Howli. The narcotics would be carried by the Keriwala, the Bhai Ziaur Rahman of Howli, who would supply the same to consumers in different areas of Kamrup like Amingao, Baihata, Rongia, Hajo PS, etc. Based on the input, a team was formed.
Who is
and,
Ziaur Rahman?
Ziaur Rahman, he is appearing. Based on the input, a team was formed, and in the evening, it was found that the bus was parked at ISBT and only the handymen were available. Watch was kept over the vehicle, and one's driver, namely Mohammad Sahabuddin of Roha, was picked up from Hatigao. So he was picked up from Hatigao, Lordship. Hatigao PS area, while the recipient Ziaur Rahman was picked up from a lodge near ISBT. The OC Gorsuk PS was informed and the manager of the bus was summoned. The bus was checked in presence of witnesses and found 35 soap boxes packed in heroin in a pink colored bag kept in the backside of the bus. The narcotics was weighed and found to weigh 455 grams without soap box cover. The driver was Mohammad Sahabuddin of Rohat, 2 handymen, Uttam Nath of Bokolia and Sofiur Rahman of Gwalpara, 1 receiver, Keriwala, supplier to Kamrup, and other areas where Ziaur Rahman, Howli were arrested. The bus and narcotics have been seized. 1 driver, known in peddling circle as Ali driver, alias Ali Bhai of Sibsagar district, fled on having come to know about the police exercise and efforts are on to nab him.
No, you were arrested because you were driving the said bus.
No, not driving, Lordship. I was the driver of the bus, but at that moment I was not there. Now they have to show any material that how I am connected with the contraband, Lordship. Because in the back of the bus, there were other luggage were also there of the passengers. 1 person also fled away from the place of occurrence. That Ali driver. And now, Lordship, may I see the forwarding reports, page 15. Only ground which I cannot answer, that is ground number 2, sufficient evidence found against him. What are those sufficient materials? That my learned friend can please do lordship. Apart from that, there is no incriminating materials are placed before the court. And second thing, your lordship will notice that under the above facts and circumstances, they have been arrested down below, lordship. I am reading last 2 lines of forwarding report. Have been arrested and forwarded to honorable court. The grounds of arrest has been communicated to the accused person by serving arrest memo and notice under section 47 BNSF. The accused person has been medically examined by Gov doctor and also observe all necessary guidelines. So nothing about 48. I have annexed that 48 notice by filing additional affidavit. That shows it was only sent to the police station concerned. No relative's name is mentioned, nothing is there whether it was served or not. On merit also, lordship can consider my whether there is any incriminating material against
Yes.
her.
I'll come to it. Let us finish one case.
In regard to this lordship, what I can see lordship in the FIR or in the forwarding, it is clearly stated that lordship, one of the handyman was available at the point of time lordship. And from that handyman, it came to know lordship, there are 2 other handymans are there. This is Uttam and Saifu. And the name of the driver also came to know lordship. And regarding the 47 lordship, I have also looked into it lordship. In the record lordship, I have not found the 47 and 48, so it need to be called lordship.
No, what is the material to show that who kept that contraband in the bus?
Because the bus was in the
Parking.
lordship.
Park's
Oh, is
condition
there
in the
park?
ISBT.
But lordship, if there is park, it is in the back side. If it is not there, they should have come, put it outside lordship. Why they are keeping it in the bus?
No,
lordship?
I'm not on. What materials are there to indicate that it was the driver or handyman who are aware about the fact that it contains heroin?
To be honest, lordship, I want to state here, lordship, because they have filed one affidavit, lordship, additional affidavit regarding that 47, lordship. So I have looked into this fact only, lordship. I have not gone through properly, lordship. Because of that, lordship, 47. I have seen that it is no 47 is there, lordship. To be
47
honest,
is there, but,
to be
48
honest,
is not
lordship, it is not 47 is also not there, lordship. So to be honest, lordship, I have not gone through properly, lordship, because of that. Because they have submitted me 147 and 48. Through an additional affidavit, lordship.
So what do you suggest?
So, lordship may call for the 47 because they have asked for that, lordship.
No,
No,
that,
their submission is that 48 notices
Then lordship,
in the form, it has been sent only to the police station.
it may be lordship, but I have not seen because it is not there in the record, lordship. Lordship may look into it, lordship. 47 and 48 is not there
I have an exact
in the
certified
CD,
copy.
lordship. But in the record, I have not found that. So I was supposed to pray for an updated because of this 47, 48, because they have paid for that. And I need to look into the record, lordship.
We'll call for the scan copy again.
Lordship.
Lordship may consider my
With
background merit
the
also.
47 and 48.
Because already I have submitted on merit that if they can show any material to connect me with those of contraband lordship, I will not praise lordship. Lordship has already heard my submission. He can make submission tomorrow, lordship. If any material is there, he can place before your lordship.
If you have no problem, then I will definitely lordship
Yes.
after on next day. Then he cannot submit on 47 and 58 then.
That your lordship will decide.
Then he will know lordship, then he cannot decide on 47 and 48 because it is not there in the lordship.
Mr. A. Ahmed, learned counsel for the petitioner. Also Mr. K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioners, namely Uttam Nath and Soifur Rahman.
Uttam Nath and Shahabuddin, he is for procurement.
And for petitioner number 2, Lord.
No, but this, you are in bail application 2513.
Yes, I am for petitioner number 1, Uttam Nath.
I'm for petitioner number 2, Lordship.
In a same bail application,
Subsequently for Kanak Kama 5.
joint bail application,
Joint.
or two sets.
Initially, one bail application filed, subsequently Kanak Kama final.
Uttam Nath. Also had Mr. MS Mondal appearing for Sophia Rahman. And Sophia Rahman. Uttam Nath and Sophia Rahman, who are detained behind the bars since 11/4/2025. The gist of accusation in this case is that on 11/4/2025, one Hirok Jyoti Majumdar had lodged an FIR before the officer in charge of North Guwahati Police Station, interiorly alleging that on receipt of the secret information was received through reliable sources regarding movement of prohibited narcotic drugs from Aizawl to Kamrup in bus number AR 11B 8912. By the drivers and handymen of the bus. Driver and handyman of the bus. The said narcotic drug was meant to be supplied to one Afaz of Howli. And it is also stated that it would be carried by one within inverted comma, Kariwala, alias Ziaur Rahman of Howli, for distribution of the said narcotic drug in different areas of Kamrup district. Based on the aforesaid inputs, a search team was constituted and it reached the ISBT Guwahati, where they found the aforementioned bus parked there. On search of the said vehicle, 35 numbers of soap boxes were found carrying heroin weighing about 455 grams. Stop. You are for?
I am for Mr. Uttam Nath and Sahabuddin Ali. Handyman.
Sahabuddin is not in this case.
In the bail application number 2704.
What is your submission as regards Uttam Nath?
He is the driver of Sahabuddin. He was in Hatigao. He was called by police. He came to ISBT. Subsequently, he was arrested.
And Uttam Nath, what is your
He is
submission?
the handyman.
What
He
is your
did not
submission?
have any knowledge about those contraventions. Those bags were, the bags was there along with the luggage of the passengers.
He submits,
Passengers luggage.
he submits that the present petitioner, he submits that the petitioner named Uttam Nath was not aware about the content of the luggage kept on the backside of the bus. Stop. He further submits that though notice under section 47 of the BNSS was served on the petitioner, number petitioner Uttam Nath, the notice under section 48 was sent through WT message.
Yes.
Very good.
WT message, I have annexed that additional affidavit, Lordship. Two additional affidavits filed, one for Lordship Sahabuddin, one for Uttam Nath.
Through WT message.
And it was addressed to Lordship that officer in charge of Bokolia PS.
And said WT message was addressed to officer in charge of Bokolia police station.
And regarding Lordship that Sahabuddin, his Lordship 48 notice was addressed to officer in charge of Roha PS.
No, Sahabuddin, we are not taking it. That is a different case. What is your submission?
My submission is that Lordship, it was sent to officer in charge and officer in charge never served the copies to the relatives. And in fact, in WT message, no relatives names are mentioned, that it has to be served to those persons. And no Lordship serving report is submitted.
Last की लिखने. Bokolia police station. He further submits that in the notice purported to be notice under section 48, nothing was stated as to whom the said WT message is to be served, as no name of the relatives is mentioned there. Where is the WT message?
Page 30 of my additional affidavit.
Further submits that the prosecution side also has failed to show that the said WT message / notice under section 48 of BNS was in fact served on the relative / family member / nominated person on the petitioner. Hence, accordingly, he submits that the prosecution side has failed to show that the petitioner is in any way linked with the recovery made in this case, as well as the fact that the notice under section 48 was duly served on his relatives, and hence he prays for a long-term bonding. Your submission is similar or different?
Similar, Lordship.
Lordship, I only want to.
Except 48, Lordship.
48 you have.
They have not filed any additional affidavit or broken record.
Similar means what?
The others are on merit.
Mr.
He was also handyman.
Mr. What is your name?
MS Mondal, Lordship.
Mr. MS Mondal, learned counsel for the second petitioner, namely the Tofur Rahman adopts the submissions made by Mr. A. Ahmed, except the submissions as regards non-compliance of service of notice under section 48. On the other hand, the additional public prosecutor has submitted that he has not gone through the scan copy of the case.
But I only want to show lordship, one thing lordship, only one thing lordship. In the petition.
You
30
make your submission
Lordship.
together.
But he has stated that they both are not present. But in this thing, lordship, in the judgment, lordship, one order copy, it is stated that handyman Uttam Nath and Safir Rahman were already present with the vehicle. Both of them are present, lordship.
Yes.
No, I have said
No,
lordship that
he is
and driver
mixing up.
was in some other.
You have
place.
mixed two cases. Shahabuddin's case is a different bail
Lordship.
application.
Lordship.
So both of them were present.
Lordship.
But
it
their
is
plea is
2%
that they were not knowing
Lordship.
what is the
I will look into the
content of-
CDR, lordship, then I can come into know,
Yes.
lordship.
Calicanas.
এইটো নথকা
And therefore-
সময় দুটা কথা কওঁ।
Therefore seeks some more time to go through the same. The prayer is allowed.
On 19 lordship.
Let
if
this
possible.
matter be listed as part heard matter on 19th of November.
No problem, much obliged.
Regarding other case, how many cases are there?
Item 31, my line of candidate hearing. In item 32, my submissions will be same.
Yes. Item 32,
Lordship, only one thing is different.
we'll take it up on 19th.
Yes, 32 same submissions and 31 my line of candidate.
We will not reflect the submissions now.
Lordship.
In item 31 and 32.
Lordship. 31, only one thing is different, all other same.
We are
That
not
is- That
reflecting
is,
it.
I am a student of BA third semester, and I studied in Milonpur College, that is Kaljar. It is 5-6 kilometer distance from Howli. And on that day, I came for receive a repair mobile in Guwahati.
You were in the said bus.
Lordship,
You were in the said bus.
bus,
Where,
bus,
where you in this sense, found in the said bus?
no, I was not there. I stayed that day in
You
a
were
hotel.
arrested later on.
Lordship,
Whether you were arrested later on.
later on.
Okay.
Later on, I stayed in a loss on that day to receive the my mobile in the next day, Lordship. I have annexed,
Puttur,
Lordship,
31.
I have annexed my mobile invoice, that is repairing receipt in page number 18-19.
Heard, Mr.
And I am not directly, indirectly contacted with the bus.
What is the name?
Actually, I am appearing on my colleague Moinuddin. I am M.M. Rahman.
Heard Mr. M.M. Rahman appearing on behalf of Mr. Moinuddin, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner's main contention is that the petitioner is a student and
Nothing found from me.
nothing was found from his publication. When were you arrested?
On 12/4/2025.
When the contraband was recovered?
Nothing. Yes,
When the contraband was recovered?
And they all were arrested and subsequently on 12th, all were forwarded to
on 11th.
On the other hand, learned additional public prosecutor prays for some time to go through the scanned copy of the records and before he makes his submission. Prayer is allowed. Let this matter be listed on 1911 along with bail application number 2513/2023. And 32 also same only. 32 is this matter along with the above two cases on 19. We'll discuss your submission on that day.
Deeply organized.
My lord, this is 483 DNS, my lord. Petitioner is in jail from last 178 days, around 6 months. My lord, the matter is charged Fosco, section 4 of Fosco is also involved, my lord. There is a love affair, perhaps it is admitted by the victim girl.
What is the status?
My lord, as of now, the cognizance is not yet taken by the Planet Court below.
Only cognizance taken on 27/8,
27/8.
2025, cognizance taken under section 20.
Possibly, my lord, pending for charges.
Production and ethics.
Why trial court has rejected? Rejection of the trial court.
My lord, earlier trial court rejected my on the ground that the investigation is going on.
Now, after completion of the investigation,
No such application was filed because this petition was filed on 27/8/25.
now what is your ground now?
My prayer is my only, my lord, since the 178 days is there and the police already submitted the charge sheet. So at this stage, he may be released on bail and let him face the trial.
No, after the examination of victim girl. Let the victim girl be examined.
There's another matter, my lord, item 38.
38 is also there,
From the same case, my lord. That is an anticipatory bail.
antecedent bail,
Same.
same case, my lord.
Let the victim be examined.
The only thing, my lord, in the anticipatory bail application, POCSO Act is not there. And the sections which are there are, my lord, like punishment is up to 7 years. So in that case, they can very easily appear before the trial court, my lord. There will be no, otherwise no bar on the part of the trial court to consider their.
And in item 34, my lord, 10 copy of TCR call for.
Not.
Not received.
Whatever it is, the case relate to lordship, theft from a transport vehicle lordship. And serving on habitual receiving stolen property. These two sections of charges was filed. We are on interim. We duly appeared before the court lordship and court allow us to remain on previous bail and next date is fit for CC lordship. The certified copy I have obtained. If lordship may allow the bail or lordship may call for the TCR lordship. It's up to court.
You are on interim.
I'm on interim. We are on interim. I leave it to court lordship only.
You
This is the order lordship.
appeared before the trial court.
No, we have already appeared, we have gone for bail, thereafter the case was committed to session. In session court, we appeared and we filed a petition
Why interim bail?
for previous bail. That was also allowed lordship, now the case is fixed for CC.
You are on bail.
We are on bail lordship,
Who granted you bail?
court, this court
This court.
lordship,
By which order?
order lordship will.
10
1999.
10/9. No, 10/9 given.
1999.
Then why
charge
this
sheet,
matter has not been disposed of? The bail was not interim bail.
Bail was on interim only lordship. TCR was called for.
In interim.
During the pendency of this bail, charges was submitted lordship. Due to Puja vacation lordship, we are granted interim and TCR was called for lordship. I think
Okay,
two
then
days.
You have appeared before the trial.
Lordship, we have appeared, the case was committed to sessions, we have appeared before the sessions also lordship.
Okay.
And we
Lord
made it,
Mr. S. Munir, learned counsel for the petitioner. Also Mr. B. Sharma, learned additional public prosecutor. This. The learned counsel for the petitioner has submitted a coordinate bench of this court had granted interim bail to the petitioners by order dated 19/9/2025. And thereafter, the committal court had committed the PRC case number. What is the PRC case number?
I'm sorry, Lordship, the other, next page is the order of that, session, trial court, committal court, Lordship.
PRC case number 3186, 2025. He further submits that accordingly, a sessions case number 209/2025 was registered. And on 29/10/2025, all the petitioners have appeared before the trial court. And they were allowed to remain on previous bail by the said court. Stop. As it appears that the petitioners have complied with the conditions imposed while granting interim bail to them by this court on 19/9/2025. And as they have appeared before the trial court in sessions case number 209/2025 and cooperating in the trial, the interim bail granted to them by this court on 19/9/2025 is hereby made absolute, subject to the condition that they shall continue to cooperate in the trial. This bail application is accordingly.
Much obliged, much obliged. That will be a part of record, Lordship, that,
You can take it back.
Lordship. Much obliged.
The city was called for,
CD is there.
My CD notice in my name.
last, it is the third time it has been listed for hearing.
My
What is the case?
notice also not served, my lord. Here
Approximate-
also 6 is there, my lord.
They have taken steps as per the procedure, my lord, as per the direction of this honorable court.
You take information.
My lord.
Heard Mr. A. Roy, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that some more time may be granted.
My lord, here I have received one report that, my lord, that case was transferred to Bongaigaon, my lord.
That,
That's
that
why-
instruction has already been placed and it has been recorded by this honorable court on the last occasion.
You call for the case diary.
My lord, from Bongaigaon.
Place some more time to call for the case diary from Bongaigaon Police Station. The prayer is allowed. It also appears that the notice issued to respondent number 2 is not yet served. This, the, then an additional public prosecutor
lord.
is requested to take the information regarding service of notice upon respondent number 2 from the officer in charge of the concerned police station and let this court know about the same on the next step fix when let this case be
Can be
listed
listed on 27th, my lord.
on 27th of
My lord.
November.
What happened in this case, Lordship, there's a earlier one, charge sheet was, part charge sheet was filed, Lordship. And, subsequently, this petitioner approached before this honorable court. And after interim, she appeared before the IO, and thereafter one supplementary charge sheet was filed, Lordship. When you have checked the record, Lordship, the earlier part charge sheet has come, Lordship, the second one,
Second is not available.
is not available, Lordship.
So it may be called for.
The Supplementary charge sheet is
After we got interim, we appeared, thereafter supplementary charge sheet was filed, Lordship. So he
against,
could not find out the statement of this petitioner, Lordship.
heard Mr. S. Munir, learned counsel for the petitioner. But what is the offense?
Often, Lordship, with the fake supply orders and all, Lordship, this led by his husband, mainly her husband, and thereafter some other people are there, Lordship. And she was also came into some 2-3 scene, Lordship, so her name was incorporated in the Lordship FIR. Or Lordship may, if Lordship may please, we are already on interim. If Lordship may grant us 15 days time, we will surrender before the, we'll apply for the regular bail in CGM court also, as charges have been already filed.
Yes.
That can be also done, up to Lordship.
Instead of,
Otherwise, Lordship, I can then focus on the points on what she has been, Lordship, the evidence against her, Lordship.
no, suppose there is evidence, assuming that there is evidence against her.
Lordship.
But if she cooperates, then why to detain her?
Otherwise, materials are there, Lordship, but
But let her
that
face.
may be reflected, Lordship.
If you object, Lordship, let the statement come, Lordship. If you-
No, no. We are disposing.
Lordship.
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that by order dated 28/2/2025. The petitioner, what is the name of the petitioner?
Sudipta Sharma.
Sudipta Sharma was allowed to go on interim bail by this court, by a coordinate bench of this court. And accordingly, she has appeared before the investigating officer and has cooperated in the investigation. However, after filing of the after her appearance before the investigating officer, a supplementary charge sheet has been laid against the petitioner, showing her as one of the accused.
But I have not seen the statement, Lordship.
And I don't have the number also, Lordship, right now, this charge sheet number.
I looked into, but I have not found the petitioner statements are there, Lordship.
Charge sheet has been laid on
Lordship. Charge sheet. But the charge sheet that is presented before the Lordship, it is against, basically before, against main accused, Lordship. That is her husband, Lordship.
now whether supplementary charge sheet has been laid or not
Supplementary charge sheet has been laid
against
against,
present petitioner.
That I have not gone through the charge sheet.
that is not written because I have seen, Lordship, this is the, Lordship may look into it. It is basically against the husband of the accused, Lordship, Bharadwaj. It is there, Lordship, in page 56.
However, as the copy of the said charge sheet is not before this court, again, stop. Learned public prosecutor, on the other hand, submits that copy of the supplementary charge sheet is not before this court. Therefore, he is not in a position to inform this court as to whether charge sheet has been laid against the present petitioner, and if so, under what provision. Hence, he seeks some time to take information. You can take information.
Lordship, we cannot know, but because Lordship,
Hence-
scan copy.
Hence, let the copy, because this is pending since February.
This thing is only going on, Lordship.
But if you look into it, Lordship, basically it is not, the petitioner's name is only husband of the petitioner's name is there, charge sheeted, Lordship.
In the main charge sheet,
Main charge sheet.
Main-
in the
Lordship.
supplementary,
Supplement is not there, Lordship. That is the problem, Lordship.
It
It
is of
is- it is-
2024, Lordship.
Lordship,
That's
it is only against her husband, Lordship.
supplementary charge sheet,
Supplementary charge sheet, Lordship, as per our information, date has been 2/6/2025.
Hmm.
After
you
getting.
take information
Right.
and let this court know.
No problem, police station again. Because as it has been already charge sheet, we don't have the
আমার next
information.
date আছে গিয়ে। 18. We'll do one thing, Lordship, we'll obtain the certified copy from their Lordship.
In view of the submissions made by Learned
Oh, time.
Public Prosecutor, Learned Counsel for the petitioner submits that he may be granted some time to submit certified copy of the supplementary charge sheet before this court. The prayer is allowed. Let this case be listed again on when, Mr. Mani, when,
apply করবো লাগে। 18, can it be possible?
it is possible. Will it be possible on your part on 18?
18. Much obliged.
May I please, Lordship? Lordship, charge sheet has been filed in this case and a scan copy was called for.
This is anticipatory bail,
Yes, Lord. My lord.
POXO matter.
POXO matter absconding, my lord.
Why anticipatory bail?
It's sexual assault, section.
President, Priest bail application on 482. My lord, I take your lordship to affair.
Mehta,
Your lordship will find in page 9 that one, my lord, one, one my lord, Rajibul Islam Lashkar was the driver driving the vehicle, and from his vehicle, my lord, in a secret chamber, the suspected heroine was recovered. And he was arrested on, my lord, on 28/8/5/24, and case was charged on 28/4/24. Till today, no trial is started, but my lord, in the meantime, while
how
charge.
trial will start?
My
You
lord,
you are
it is
not before the
here,
court.
my lord, absconder and PNA.
That's right. In the charge sheet, my lord, page 13, only mentioned that I am absconder. As such matter, I am wanted. But
No other acquisition,
no other record. That's why your lordship was.
but
that
you
they
are the
also-
driver.
Driver, there is a full, it is in his position, he has admitted that he has carried this. And there are not only me, there are 3 persons. I am not of course concerned with others. My name is Riazul Haq Lashkar. Page 13 you will find. And in the charge sheet also
Your
last
name is
slide.
Riazul or
Zulu Hawk.
Julu Hawk Laskar.
My name is Julu Haq Lashkar, my lord. Page 15.
Eligible.
Page 15, serial number 2, page 15, below, my lord, Julu Haq Lashkar. He is absconder. But under 173 CRPC, it is required mandatory that there should be some allegation, what I have done, what role I have played.
You have gone through the,
My lord, I have gone through the record before that, my lord, here on 11/6/2025, my lord, inquiry officer was examined, my lord. And after his examination, court is satisfied and he was declared as proclaimed offender, my lord. PNA issued proclaimed offender, my lord. And thereafter, my lord, I have gone through the record, my lord. Here, from the statement of the one of the accused, my lord, it reveals that, my lord, all of them purchased the contrabands from Mizoram, my lord, in the last night, my lord. And on the-
where?
I have flag mark, my lord, in the statement. In the LCR, my lord. last part.
Yes.
All of them have purchased the contrabands from Mizoram, my lord. And when only one, my lord, he went to sell them to the one of the, my lord, drugs dealer, my lord, he was apprehended.
I did not go to sell this drug,
But purchased it from the Mizoram, all of them.
but the why it was not reflected in the charge sheet. It is a very good case. Why there is no witness from Mizoram from whom I have purchased?
It is a matter of trial, my lord, and he
No,
was
no, no,
declared
sir.
as proclaimed
You-
offender.
When you prepare a case, project a case, curtailing the fundamental rights of an individual, you must think over.
No, apart from the statement of co-accused,
My lord.
Yes,
There is-
that's Tufan Singh's case, my lord, is also
That
there.
is defined, my lord. Tufan Singh is, my lord, defined, my lord. My submission is that during the time of investigation, my lord,
now in this case, charge sheet
is-
has been laid.
search it submitted, my lord, it is not possible to, there may be some eyewitness or any other witnesses, my lord. From the, it is linked, my lord, from one another when.
Then
one
how you
informant-
can file charge sheet?
My lord,
On what basis you have filed charge sheet? Suppose you fail to collect evidence,
my lord.
there has to be some evidence.
My lord, evidence is there, my lord, from the other accused person, co-accused person, my lord.
Co-accused person's evidence is not admissible as per Tufan Singh's.
That may be also, my lord, but from the, my lord, for the purpose of investigation,
They are not prosecution witnesses
my lord.
in the
But
trial.
otherwise, it is difficult to go through, my lord, if one.
How will you prove charge against them?
Right.
What evidence you will adduce for proving charge against the present petitioner?
If the investigation time, my lord, we do not believe the statement of the co-accused, my lord, then investigation will be incomplete, my lord. How
No,
did-
I am not on that.
My lord,
Suppose co-accused implicate,
my lord,
then whether the work of investigating officer stops there or whether he has to collect further evidence to substantiate his case. Merely co-accused have implicated and no further collection of any evidence. Then where your case will stand.
my lord, that's why he is trying to, my lord, apprehend the accused person, but he is not. cooperating
But
with
you
the
have
accused.
filed charge sheet without collecting.
Right.
You have
You-
not kept the investigation pending.
He is not cooperating, my lord, during the investigation time, my
How
lord.
can I cooperate?
Mhm.
His action, PNA also issued against him, my lord. Court below also.
Apart from this flag co-accused statement,
My lord.
there is nothing.
My lord.
You have Tufan Singh's case.
Yes. I'll give you tomorrow, madam. I have not brought today. A big judgment.
Well, if PNA is issued, my lord.
Keep it
if there
pending,
is a
madam.
intent-
Tomorrow I'll give to one Singh case.
PNS bill is granted or not, that may be also considered.
No, that is a bar.
My lord.
But suppose no case has been made out against. You fail to make out a case against. You bring that judgment tomorrow. You also go through. Is there any other material apart from the co-accused statement?
My lord.
Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma,
Tamil Nadu.
learned,
You know,
learned.
co-accused statement is not admissible, 27.
And you also answer my query. In case if an accused is declared as a proclaimed
My lord.
offender under the provision of BNSS,
My lord.
whether can he be granted anticipatory bail? On this
Sure,
also,
I'll bring that also.
Tuesday,
My lord.
Tuesday.
My lord.
Tuesday. Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. learned counsel for the petitioner, learned additional public prosecutor submits that after going through the scanned copy of the case diary as well as charge sheet placed before this court, he could find out that in the statement of the co-accused persons, it has been reflected that the present petitioner is also amongst the other co-accused who had procured the seized contraband from Mizoram.
Right.
However, he fails to show any other materials in this regard. Therefore, he seeks some more time to
Right.
go through the scan copy. He also submits that the petitioner was declared as an proclaimed offender
I ordered it 11,
by the trial court by order dated 11/6/2025,
6 madam, 25.
2025, and therefore this may not be a fit case to grant of anticipatory bail. On the other hand, learned additional public prosecutor, on the other hand, Mr. S.C. Bishwas submits that the statement of co-accused recorded under section 67 of the NDPS Act may not be used as an evidence against the co-accused in a trial involving offense under NDPS Act. And in support of his submission, he cites the ruling of the apex court in the case of Tufan Singh versus State of Tamil Nadu, reported in citation Lekhlena. Reported in so and so. He further submits that as regards the plea, as regards the contention raised by the public prosecutor regarding declaring the petitioner as an proclaimed absconder, proclaimed offender, when there is no material proclaimed offender, he seeks some time to place some authority in some and his counter submission in this regard on the next date fixed. Let this matter be listed on 19.
Part heart.
Not need, otherwise it will come to this court only.
If it comes, well and good for me. Oblige. 41.
Please, Your Lordship. It's an anticipatory bail, my lord. CD is called for, I was in interim, my lord. And CD is called for.
It is there.
CD is there.
You have appeared,
Yes, my lord.
you have cooperated.
Yes, totally, but I only want to point out one thing, Lordship. One of the witness has stated that, Lordship, he know that these persons are dealing in smuggling cattle, Lordship. And he said that it is the FIR is on 22 and information got on 21. And this person has stated that on 20, he saw this person along with another person, Lordship, unloading these things. Lordship, may kindly look into that statement. Otherwise, his statements are recorded.
Okay. Heard Mr. M.A.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner was granted interim bail by this court by order dated 11/9/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. Stop. Learned additional public prosecutor has produced the case diary and submitted that though during the investigation, one of the witnesses whose statement was recorded has seen the petitioner indulging in similar offense in the year
No, in the day before the FIR was lost, Lordship.
on the day before the FIR is lodged in the instant case. However, he submits that the petitioner has appeared before the investigating officer and his statement has been recorded. Stop. Since, no, stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Stop. Since the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to him by order dated 11/9/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary.
IA pending appeal one.
What is the offense?
376, my lord. Allegation is that, my lord, the petitioner went to her house. Earlier, he was a driver of her family, my lord. He left. Thereafter, my lord, that he came once after he.
You have filed objection.
Yes, everything, my lord.
My lord.
Just comparison I have prepared just to save time, my lord. I would ask, one was any comparison. Just as, my lord, list of date like if I have given.
Yes.
What I find, my lord, subject to your lordship will see. Maybe concerning party, my lord, she was caught red-handed, so that this case was, my lord, that frame. Your lordship can see FIR page, FIR one. Kindly have a look to page 1 of my compilation. Your lordship will find page 3, English version line.
Yes.
You'll, that is dated, my lord, 9/7, FIR was lost, my. And date, I have given date in this, here, my, your lordship got this copy, my. All the list of date given, it will make it easier, my. Page number also given, my. Now, with due respect, I would like to stay there on 7/7/18. After 2 days, taking advantage of absence of my parents and other persons at home at around 1 PM, daytime, my lord. Accused entered my house, closed the door, and by threatening me that he would marry me, forcefully damaged my chastity against my will. When I made hue and cry, nearby neighboring peoples came and rescued me. This is the FIR, my lord. Then your lordship kindly see, there are cases that, my lord, when neighboring people rescued me. I request you to kindly investigate the matter and take legal action against. Now PW1, my lord. Your lordship kindly see. The medical report, my lord, FIR was lodged on 9/7. Your lordship, if your lordship have this paper, this will make it easier, my lord. This one, my lord, just.
Yes.
Your lordship, date of occurrence 7/7. FIR 9,
Yes.
9/7/18. Then, my lord, age 23 years, my, it will reveal from the page number 1. Her age, medical one done on 10/7/18. Nothing was found. Then statement of victim under 161, 11/7/18. The arrest is, my lord, after 16 days he was arrested. And their cases, my lord, the villager came and villager caught him and handed over to the police. It has come in the witness, my lord. So presence of the evidence is doubtful. Now I take your lordships to the position of PW1 victim. Just, my lord, that will do, my lord, I think. Instead of going further, my page 11. Chief, my lord, I am the informant. I know the accused who is present in the dock today. Occurrence took place
Page
on
number?
page number 11, PW1. Or 11 a compilation, my.
Okay.
What, you also got it?
Yes.
I am the informant, victim of the case. I know the accused who is present in the dock today. Occurrence took place on 7/7/18. It may be mentioned here that the accused used to work as a driver in our house. That is important, my lord, for 3 months prior to the incident. And thereafter, he left the service and used to visit our house even after leaving employment in our house. On that day also, accused came to our house and like other days sat in our house, asked water from me. At that time, accused asked me whether my parents was at home house. When I stated to him that they were not, then the accused closed the main door, committed so-and-so. Accused forcibly tore my wearing apparel. I read he even cry in the house. Thereafter, the other villagers came and repeatedly dusted the main door of the house. Your lordship, they dusted my lord, and the bolted of the main door open, and thereafter rescued me from the clutches of the accused. Thereafter, the villagers caught hold of the accused, kindly note my lord, and handed him over to the police. The police arrested after 16 days, my lord, after 16 days of the occurrence. Forwarding report page, just your lordship will get forwarding report, my lord, page 10. Just it will make clear, my lord, that page 10. Just have a look, my lord, this
No, but he was handed over.
handed over to the, yes, handed over regarding house. Thereafter, the other villagers came and repeatedly dusted the door so and so. Accused, thereafter, they accused and handed over him to police. So he ought to have been arrested at that time, or police allowed him to go. But he was arrested, your lordship, page 10, your lordship will find 23/7/18 he was arrested. Just my lord, page 10. Forwarding report. 23/7/18 after 16 days. So it itself shows his, my lord, his presence in that the place of occurrence. Then thereafter my parents came.
No, what it indicates.
It indicates that, my lord, two things. Either whole thing while he was not there. And because he has gone, he has purchased a new car. It has come, my lord, in the evidence. He purchased a new car and he started his own driving. That maybe that there may be lost to them. Another aspect is there, my lord, villager might have caught red-handed and ultimately he was allowed to go. And thereafter the case was filed. That may be also that one. Because not a single villager examined, not a single villager examined. Who examined, my lord? Paternal uncle saying that he is a Gaubura. And none of them, my lord, your lordship will find that my other compilation, the victims, total 7, my lord, 7 victim parents, Gaubura stated, but he is her own uncle, my lord. Then, my lord, doctor, then sister, then Ayu. And I have just given a judgment, my lord, very recent, my lord, idea one paragraph 5 only. The same thing, my lord, it was stated that maybe that caught red-handed, so ultimately they made, my lord, the case of rape, my lord. So this may be the case instead of going to further, my lord. So for the prima facie, I find that it is not a case of rape. If there is rape, it is consenting. If there is nothing, what is that because of the diver, because he has gone purchased a new car, that may be the reason. Paragraph 5, 2011-14 SCC. Paragraph 5.
Yes.
Last portion, my lord. On the contrary, third line, on the contrary, the findings of the High Court that the prosecutor was a consenting party appeared to be correct. And it was perhaps when the accused and the prosecutor had been caught red-handed that the story of rape had been cooked up to salvage the sum of the family honors. This is often the tendency in such matters. The High Court has therefore gone completely wrong in dismissing the appeal even after its categorical observations. I find in this case also the same thing, your lordship. Same thing they repeated. Villagers came, handed over the police. But where if handed over police, I ought to have been arrested.
Now, is it your plea that there was consensual? You are, what
in
is
my
your?
humble my lord, submission, maybe it may also happen. I am saying maybe, my lord. Maybe consenting party court guardian, both are consenting, and marriage, question of marriage also come, my lord. They wanted to go marriage, I refuse. That also come in the father's witnesses, my lord. Father's evidence, it has also come, marriage.
What father says?
Yes, your loss will find Mary PW, page 19, one line. There you go. Yes, cross examination. Type
Yes.
copy we have given, English, otherwise that was one English also might have been a type copy. Original also given. Your loss will find bottom and cross examination. It is not a fact that we the parents, last from bottom 5-6 line above, my. It is
Yes.
not a fact that we the parents gave any marriage proposal to the villagers regarding accused marriage my daughter. At the time when accused drove my vehicle, I gave him rupees 9,000 per month as salary. About 3 months prior to the date of occurrence, accused purchased his own vehicle and drove the same. It is not a fact that as the accused did not agree to marry my daughter, so we lost this false case against him. It is not a fact that I had to falsely before the court today.
This is suggestion only.
That is, but it has come from the mouth of that here, madam. Suggestion, and it has come in the chief also, madam. Your loss will find. Deposition, my lord, your lordship, page 19, first, but 3-4 lines, madam. I know the accused, he worked as a driver in the one of my relatives, so-and-so. Occurrence took place on 7/7/18 at 1 PM in the afternoon. At that time, I was in Guwahati due to work purpose. At about 1:45 PM, I received a phone call from our villager and informed me about the occurrence and also stated that the court hold of the accused. And so I asked them to keep him confined in my house till I arrived. Then I informed my wife. Thereafter I arrived and heard about the incident from the villagers. None of them examined. Then my daughter also informed me about the incident. Thereafter police was informed and took away the accused. And I lost the jar on 7/7/18. It is belied by the forwarding report. Later on, I heard that the police gave the accused in Jimma to one Abed Ali. Later on 9/7/18, we went, Abed Ali was not examined. 9/7/18, we went to police station to know about the case and not seeing the accused there. We asked the police and then police took another Azhar on 9/7/18. That was not exhibited. Thereafter, police got my daughter medically examined on 164 statement was recorded there was once. And medical report, if you lost kindly see that page, you will find medical examination. Doctor is page 25. Page 26, you will find this opinion. Age is about 20 years, my opinion. On the basis of the physical examination and radiological laboratory investigation done on the so-and-so, no injury detected, though no evidence of so-and-so. Age is about 20. And top, page 26, top, madam. Injury on the body not detected at the time of the examination. If there is a struggling, my lord, evidence of struggling also not there.
Then on what basis conviction was made? On the basis of the statement of the victim girl.
So, whether you also will believe if there is a contradiction and if there is taken the circumstances, my lord. It is true. But whether it is sole evidence of trust or the can you also believe on the face of all these things, my lord. He has searched and handed over the police. Villagers came. None of the villagers examined, my lord. So who will support her, my lord? If any one of the villagers who was present at the particular place, my lord, of course, no corroborating witness, my lord.
Yes.
My lord, I think the case, prima facie, I think subject because the details will be required, my lord. So far bail is concerned, 5, 6 months already occurred, my lord. Local person, my lord, your lordship may consider. This is my submission.
My lord, here we have filed our objection, my lord, as it is in the
Yes.
previous conviction, my lord.
Yes.
And here from the, my lord, deposition of the witnesses, my lord, record also, it was found that the PW1, my lord, who is the victim, my lord, in the instant case, my lord. In her deposition, my lord, she has categorically stated how he was, my lord, forcibly, my lord, done sexual assault, my lord, by the accused person. And from my lord 164 and 161, she was consistent, my lord. Her testimony was believed, my lord, not, there is no any, my lord, contradiction regarding her statement in 161, 164 and before court, my lord. SPW1, my lord. And lordship is well known, my lord, her statement is believable, my lord. There is no need for corroboration, my lord. And regarding the medical report, although, my lord, my senior already referred the medical report, that here in para, my lord, 28, my lord, judgment, my lord. My lord, IA, my lord, IA.
Page number?
In IA, my lord, page 28, my lord. Page 28, IA, my lord.
Yes.
Para 33, my lord. Para 33, my lord, last para.
Yes.
May I read, my lord? Though in this case, PW5 MO has opined that there is no evidence of recent sexual intercourse upon the victim in exhibit so medical report, but perusal of the exhibit as well as testimony of PW5 reveals that victim was examined on 10/7/2018, whereas the occurrence took place on 7/7/2018, as confirmed by PW1 victim. So in this situation, after examination of the victim after 3 days, there may be no evidence of recent sexual intercourse upon the victim. And it was again discussed on para 33, my lord. Para 33, my lord. Para, page 33, para 35, my lord. The same judgment, my lord.
Yes.
My lord. Even the defense, though evidence failed to prove that there was a consent and absence of injury under prosecution, victim not a factor to absolve the accused in this case as in this regard. I would like to place a judgment of Honorable Supreme Court, my lord, State of UP versus Pappu. This court held that even in a case where it is shown that the girl is a girl of easy virtue or the girl habituated or sexual intercourse, it may not be a ground to absolve the accused from the charge of rape. It has been established that there was a consent by her for particular occasion. Absence of injury on the prosecution may not be a factor that leads to the court to absolve the accused, my lord. And in the, my lord, Gurmeet Singh case, my lord, if there is some minor contradiction may be there, my lord, but for that issue, the whole case cannot be thrown up, my lord. In the state of Punjab versus Gurmeet Singh, my lord. It is clearly stated that there may be some contradiction, minor contradiction, my lord. For that purpose, it cannot be thrown out, my lord, whole case, my lord. And on the other witnesses, my lord, going through all the evidences of the witnesses, my lord, the court below has rightly passed the judgment, my lord. There is no such type of contradiction, my lord. PW1 is very much consistent, my lord, in 164 and deposition before the court, my lord. And I have already a good, my lord, as the lordship is well known, my lord.
Is there any possibility of getting a favorable order in the
No, my lord, no, my lord.
or
Here-
there is absolute no possibility?
My lord, no possibility of acquittal, my lord. In only, my lord, suspension can be granted when there is a possibility of, my lord, acquittal, my lord.
But why no villager was examined
My lord,
who had witnessed?
my
When
lord,
there were witnesses
my lord.
who could have deposed whether the offense was consensual or forceful?
My lord, that part is defined, my lord, but from the evidence of the PW150, my lord. When he entered the room, when he called for a glass of water, my lord, then when
And she even asked her whether there's any some of them. It is also true that all of them are well known, my lord. But he has left the job, my lord, as he is the driver of this family, my lord. He has left the my lord. And one important thing, my lord, here the from the side of the accused, my lord, two DWs were examined, my lord. DW1 and DW2, my lord. That were not relied by the court below. Why, my lord? That both of them are different stand, my lord. Lord,
No.
kindly pay result DW1 and DW2, my lord.
Yes, for what they have stated.
My lord, they are on different stand, my lord. That's why it is not relied by the court below, my lord.
DW1 is paid by Lord, you will find.
No, suppose DW,
Who are
What?
you?
For their support, my lord. They have examined two DWs, my lord.
to support what?
For support their case, my lord. My defense for defense of the accused person, my lord. Lord, kindly pay here, my lord, in the LCR, my lord. I have flag mark, my lord. DW, what they have said, my lord.
Page 31 of my compilation, my DW1, accused.
It was discussed as page 29, my lord.
And DW2,
My
No, I
lord,
have not, an expert may be available in the.
page 29 also in the judgment also it was discussed, my lord. In the IM, my lord, page 29, my lord. Page 29, there are 34, my lord.
that he refused to marry the victim.
No, my lord, DW1, my lord, para 34, my lord.
Yes, that he refused to marry the
Before
victim.
the informant forcefully wanted to give marriage with him, my lord, that is, but DW2, my lord, has given another person by deposing that the accused has 2 months due money for which a false case has been filed against him, my lord.
But both may be true also.
My lord.
Both may not be contradictory. Both reasons may
They
exist.
have placed two reasons from both sides, my lord. But the court below never relied, my lord, as they are contradictory, my lord. One said that, my lord, marriage
No,
due to
there
death-
may be two reasons for lodging false case.
Not this.
Not
My lord, here, my lord, a lady, from my understanding, my lord, such type of offences may never file any FIR against the someone, my lord, against some false
no.
allegation, my lord.
I'm just putting queries.
My lord,
Room was locked from the inside.
my lord.
They were rescued by the villagers.
Villagers, my lord.
None of the villager has been examined as
Right.
to what was the situation, whether there was any hue and cry.
My lord. Here PW4 is the Gaubura, my lord, Abdul Mujid, my lord.
But
Whatever may be uncle, but he is the Gaubura, my lord. PW4,
whether he was present at
PW4,
the,
my lord. PW4, my lord.
Yes. Victim is by niece, my lord. Second paragraph.
Page 23. My lord, page 20, my lord. Page 20, para 16, my lord, in the judgment, my lord.
No, judgment, my lord, we rely on the evidence, my lord. Page 23 of my compilation. Evidence, original I have. given.
Only in the compilation,
Judgment,
only,
my lord, we have come
only dates are
challenging the
here.
judgment.
Only dates are here in the
Huh?
compilation. Only dates are here.
No, no. Record of this. Evidence of PW2, 4. Page 20. Page 23 of my compilation.
I have checked my lord, PW4, my lord.
The judgment, my lord, your worship is to be, you have challenged the judgment. He did not appreciate
In the
that.
judgment, it was written from
No,
the
the judgment,
evidence.
we should not go to the judgment. Page 23, my lord. Original is evidence, my lord.
The record also available, my lord.
Yes, yes. Yes, from record, your worship, my check, man. I know the informant, victim as well as the accused. Occurrence took place on so and so. In the day, victim is my niece. At that time, I was in my own house. At that time, their neighbors started, he went cry and hearing, so I came to the place of occurrence and saw the accused was kept locked inside a room. And I asked the reason of him being kept under lock and key. Villagers informed me that the accused had so and so. He was caught red-handed where he is government.
Okay. Anything else?
My lord. My submission is the court below rightly passed the judgment, my lord. And from the evidence, it is revealed that there is no chance of acquittal, my lord. But may not consider at this stage, my lord. Only in exceptional circumstances, my lord. Only
What is the sentence?
10 years, my lord. Only in the exceptional circumstances, my lord. Suspension was given, my lord.
Only in 302 case.
My lord.
Yeah.
Exceptional circumstances where is a chance of acquittal.
Wait.
A fixed term, my lord.
Heard. Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. I.U. Chaudhary, learned counsel for the petitioner, applicant. Also heard Mr. B. Sharma, learned public prosecutor. This interlocutory application has been filed by the applicant Mohammad Nekubur Rahman under section 430 of BNSS 2023, praying for suspension of execution of sentence imposed on the applicant by the judgment and order dated 22/5/2025 passed by the Court of London Additional Session Judge within bracket FTC Rongia Kamrup in sessions case number 57/2018. By the said judgment, the the applicant was convicted under section 376 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for 10 years and also to pay a fine of rupees 5,000 and in default of payment of fine to undergo further simple imprisonment for 1 year. The aforesaid judgment has been impugned by the present applicant by preferring the connected appeal number, connected criminal appeal number 221/2025, which has already been admitted for hearing. The gist of accusation in this case is that on 9/7/2018, the victim girl had lodged an affair before the officer in charge of Sangsari Police Station, inter alia alleging that on 7/7/2018, the present applicant, taking advantage of absence of the parents of the victim girl in the house, in her house, at around 1 p.m. entered there and closed the door, and thereafter by threatening her committed forcible sexual intercourse with her. So it is also stated in the affair that when the victim girl made hue and cry, the nearby neighbors came and rescued her therefrom. In receipt of the said affair, the investigation was initiated. And after completion of the investigation, charge sheet was laid. Charge sheet was laid against the present petitioner under section 3, present applicant under section 376 of the Indian Penal Code. During trial, you were on bail.
Yes, yes, all along. We have stated.
The applicant faced the trial remaining on bail. Stop. When? Stop. The trial court, after considering the materials on record, framed charge under section 376 of the Indian Penal Code. Stop. Of the Indian Penal Code. Stop. When the said charge was read over and explained to the present applicant, he declined to plead guilty and claimed to be tried. Stop. To bring home the charge, aforesaid charge against the applicant, the prosecution side examined 7 witnesses, including.
Instead of again listing my daughter.
I will deliver the remaining, dictate the remaining part in chamber. Wait for the uploading of the order. Yes.
Your lordship allows by the subject to additional session judge come from here.
Okay.
My lord, I have a small prayer regarding item number 45. The matter has been fixed today for hearing of this matter. It has slightly urgency of the fact that my conviction has not been stayed there.
Conviction cannot be stayed.
I'll show, my lord, I'll show that why, or that is why the matter has been fixed, my lord. Because convictions, my lord, I'll show that whether, because of, he is a probable candidate of one of a party, not political party.
Oh, you are praying for staying of conviction, not the sentence.
The conviction, my lord, only on the ground that 2 years has been given, only 2 years, my lord. Sentences is of 2 years, my lord.
Which item?
45, my lord. 45, item number 45. So that is why the matter has been fixed today for hearing of the entire matters, my lord. Now, your lordship, I'm just asking for stay of the convictions because of the fact that.
No. What is your prayer now? We are not going to hear it.
My lord, that's on next Tuesday, my lord, lordship may fix the matter next Tuesday for hearing day, my lord.
Tuesday, how many matters? Tuesday, we have fixed lot of matters.
Thursday then, Thursday. So that has an giving an importance, my lord, that is why.
Thursday, if same thing happens. Okay, we are. Who is appearing for the appellant?
And we are the appellant, my lord. The state is represented by public prosecutor.
Heard Mr. P. Bora, Learned Senior Counsel, assisted by Mr. P.P. Datta. Also heard Mr. B. Sharma, Learned Additional Public Prosecutor. Due to paucity of time, this matter could not be heard today. Hence, let this matter be listed on Thursday, Kiman, on 20 November.
It's a fixed item, my lord. Malal will come.
It will be coming as fixed item only.
Oblige.
Yes.
Item number 43. This is in regard to Jimma of coal. On last 5 occasions, due to the paucity of time, it did not reach. Well, we'll also try our luck on Thursday next because every day the value of the product is going down. Perishable.
Jimma of?
coal, my lord. In one lot, your lordship has allowed in another case. The second lot, my lord, we have been, for last 5 days, 5 occasion it was listed. Small matter, but I pray, my lord, I'll take my chance on Thursday next, my lord, on 20th.
Heard Mr. B.D. Kaur, learned senior counsel assisted by Mr. H. Agarwal, learned counsel for the petitioner. This matter could not be taken up for hearing due to paucity of time. Let this matter be listed on 20/10/2025.
With regard to item number 44, my lord, can it be listed on 27th, not next week, 27th, my lord?
Remaining matters, let the registry, unless there is some urgency.
There is some obvious matter in this matter. We are expecting an interim order, this matter. I think 44, 27th, my lord. After 2 weeks.
Heard Mr.
Here,
A.
Roy.
Roy, learned counsel. No, directly he go. This matter could not be taken up for hearing due to paucity of time. Let this matter be listed
27th, my lord.
on 27/10/2027/11.
Maybe little lordship. Item number 29, admission. Earlier opposition, my lord, already left over, my lord, 2 days left over, my lord. But I am not interim, my lord. I am challenging the entire proceeding, my lord. But kindly fix the, my lord, 20, my lord.
Let the registry fix the remaining matters.
But it is, like, 27, my lord.
Item number
29, my lord.
29 on 27.
I'm also similar plea of the admission matter for watching of a criminal prosecution. So for it,
25.
only fix a only date matter, any date as per convenience of the program. Any date matter. What should we fix it?
So,
Item 25 matter.
no, we don't, remaining matters, let the registry fix. Otherwise, we don't know the list. Same thing will happen. Pray before registry.
Item 46, in fact, I have different pair. In this case, TCR was called for, but TCR has come up only of appellate court. The trial court TCR is required, my lord. That may be
Item 46.
46, my lord.
Heard Mr.
Yes, sir.
S. Sahul, learned counsel for the petition. Also heard Mr. B. Sharma. Issue reminder for the scan copy, the records of the trial court which has not been received.
Trial court, yes.
Registry to issue reminder. Let this matter be listed after receipt of the trial court records after 2 weeks.
My lord.